Good afternoon and welcome to the Assembly Committee on Commerce and Labor. Secretary, will you please take roll?
Assembly members Anderson, Carter, present. Cole, here. Hardy, Howdigi, here. Kasama, here. Miller, here. Monroe Moreno, here. O'Neill, here. Roth, here. Torres Fawcett, here. Yeager, here. Urick, and Chair Marzola.
Here. Please mark Assemblymember Hardy absent excused, and please mark members present once they arrive. Welcome everyone that is here with us in Carson City today, anyone in Las Vegas, and everyone else tuning over the internet. Excuse me. Today we have three bills: Assembly Bill 250, Assembly Bill 319, and Assembly Bill 371. I will not be taking those in order. We will also conduct a work session to take action in measures the committee has heard in previous meetings. I will not be holding the work session until later on as well. Before we get started, I do have a few housekeeping announcements. Members of the public may I can't speak today. Let me start over here. Members of the public may provide testimony in various ways, all of which is listed in the agenda. When testifying, please remember to turn on your microphone to speak and off to listen. Also remember to state and spell your name for the record. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. Committee information is available on Nellis, which can be accessed through the legislature's website. You may also watch our meetings through Nellis or the legislature's YouTube channel. We ask that public comments be kept to 2 minutes each so that everyone can be accommodated. Public comment may also be submitted in writing, either in addition to testifying or in lieu thereof. As always, I expect courtesy and respect in all our interactions, even if we may not agree. Finally, if everyone can please turn off or silence all of your electronic devices, especially your cell phones. And with that, we will hear our first item, which is Assembly Bill 371. I will now open the hearing on Assembly Bill 371. This measure enacts the Cosmetology Licensure Compact. Assembly member, you may begin when you're ready.
Thank you. Good afternoon, Chair Marzola and members of a hardworking committee in the Nevada State Legislature. For the record, I'm Assembly Member Selena Torres Fawcett, representing Assembly District 3, and I'm the sponsor of AB 371, which enacts the Cosmetology Licensure Compact. According to the Cosmetology Licensure Compact Commission, there are approximately 600,000 licensed cosmetologists in the United States. These professionals provide essential services to nearly every American during both economic upturns and downturns. This industry plays a critical role in our economic landscape, dominated by small businesses and self-employed individuals, while exemplifying gender and ethnic diversity in both large and small communities. Cosmetologists must complete a comprehensive training program covering a range of topics from safety and sanitation to technical skills, customer service, and business management skills. Upon completion of the program, a person must take exams to demonstrate his or her knowledge in those skills and their capabilities are required to perform the job. Upon passing the required exam, they are awarded with a certificate and may apply for a license to work. Licensing in the beauty industries ensures the quality and safety of the workers, ultimately protecting consumers from unqualified and unsafe workers. At this moment, I would like to turn it over to Keith Buckhout from the Council of State Governments and Leslie Rose from the Future of the Beauty Industry Coalition to discuss more details on the compact and its opportunity for the cosmetology workforce. Please begin when you're ready.
So we may be having a little bit of technical difficulties.
Maybe in the meantime,
Apologies, I couldn't reach the settings to unmute and display my video. I'm sorry about that, but hopefully my screen should now be shared appropriately. I'm sorry for the confusion. Can everyone hear and see the slides?
We can hear you. Can you make the slide a little bigger if possible?
Well,
there we go.
See.
Thank
Hopefully.
you.
Okay. Apologies, everyone. Good afternoon, Chair Marzola and committee members. Thank you for your time and the opportunity to address the committee. My name is Keith Buckout, and I'm a policy analyst for the Council of State Governments. The Council of State Governments is the nation's only national membership organization serving all three branches of state government. Throughout CSG's history, we promoted multi-state problem solving and supported states in determining their respective futures, which led us to create the National Center for Interstate Compacts. The Compact Center serves as an information clearinghouse, a provider of training and technical assistance, and a primary facilitator in assisting states with the revision and creation of new interstate compacts. In 2020, the Department of Defense entered into a cooperative agreement with the Council of State Governments to fund the development of new interstate compacts for occupational licensure. The cosmetology profession was selected through a competitive request for proposals, and between March 2021 and December 2022, CSG and our project partner, the Future of the Beauty Industry Coalition, convened subject matter experts, including state licensure board officials, legal counsel, industry professional associations, employers, licensees, and cosmetology educators to study state policies, identify best practices, and determine the needs of the profession to draft the model legislation before you today. CSG and FBIC also hosted public review sessions until all public input and feedback was heard to ensure the legislation before you today contains comprehensive policies developed through an open, transparent, and thorough process. The purpose of this compact is to create an additional optional alternative pathway to multi-state practice by allowing cosmetologists whose license is in good standing to apply for a multi-state license in their home state. Under this mutual recognition model of interstate practice, compact member states agree to recognize the multi-state license issued by the home state as authorizing practice of cosmetology within their jurisdiction. The intent here is that the multi-state cosmetology license functions similarly to that of a driver's license. The home state issues the license, and it authorizes practice in any other state that is a member of the compact. To be eligible to join the cosmetology licensure compact, a state must do a handful of things. Must obviously first license and regulate cosmetology, and then it must also require that applicants for licensure pass a cosmetology competency examination. Must also require that applicants for licensure satisfy educational and training requirements of cosmetology. And finally, states must implement and maintain procedures for considering one or more of the following categories of information from applicants. That's either a criminal history background check, a question on the application about their criminal history, a licensed disciplinary history question on the application, or a full background check. As long as the state does one of those three things, the state is in compliance with the compact. From a regulatory perspective, the Cosmetology Licensure Compact preserves the authority of each compact member state to protect public health and safety through the existing regulatory structure. Nevada retains authority over its initial licensing requirements. Further, any cosmetologist using the compact to provide services in Nevada must abide by Nevada's scope of practice rules. If a multi-state licensee from another member state violates Nevada's laws and rules while providing cosmetology services within its borders, that licensee can be disciplined and prohibited from practicing there in the future. Just like the 5 other occupational licensure compacts, of which Nevada has already become a member, and then 9 others under consideration this session. The compact will be governed by a commission consisting of a delegate appointed by each member state. The commission's authority only extends to effectively administering the purposes of the compact, and it cannot dictate licensing policy to states. Lastly, we don't anticipate a substantial additional costs for states participating in the cosmetology licensure compact. There may be some things like a small assessment for additional software required to connect to the compact's interstate licensure data system, as well as some minor costs associated with your state's, if your state's chosen delegate chooses to attend the commission meeting in person. As we know that Nevada is a state with several significant military installations, it's important to note there is a provision allowing active military members and their spouses additional licensure mobility to ensure the compact meets the needs of meets the specific mobility needs of highly mobile military families. And that's as part of our cooperative agreement with the Department of Defense. At this time, and as you heard from Assembly Member Torres Fawcett, the cosmetology licensure compact has been enacted in 8 states, and legislation to enact the compact is also available in several more this session. Thank you for the opportunity to share information about the compact, and I would be happy to address any questions from the committee at your discretion. Thank you.
Thank you, Assemblymember Torres Fawcett. For the record, if we could go next to Ms. Leslie Rost.
All right, guys, I'm on my phone now. My computer had a little problem, but Chair Marzola, co-sponsor Torres Fawcett, and committee members, my name is Leslie Roste. That's Leslie, L-E-S-L-I-E, Roste, R-O-S-T-E, and I'm with the Future of the Beauty Industry Coalition in support of AB 371. I represent many employers in your state who hire cosmetologists and often have difficulty being able to stay fully staffed. This legislation that is considered the gold standard for licensed mobility allows employers to draw from a larger pool of employees, allows cosmetologists who come to your state to get to work immediately, and reduces workload related to reciprocity applications for the regulatory agency. In addition, the compact's use of a required comprehensive database may also reduce license fraud and therefore improve health and public safety for your consumers. I understand there may be concern about the standards in Nevada being upheld. I am a nurse by training and worked as an infection control nurse prior to coming to the professional beauty industry 15 years ago as a subject matter expert. Since that time, I have worked on health and public safety in the professional beauty industry, during which I helped over 30 states evaluate and update health and public safety rules and curriculum. I also served as an item writer and evaluator for a national licensure exam and wrote science content, including infection control, for both major textbooks used in cosmetology theory education. My experience across the states can attest to the fact that all states have similar curriculum and, in fact, rules when it comes to health and public safety. For example, infection control in this industry has almost no variance from state to state because the options for how to properly clean and disinfect in a professional beauty setting are extremely limited. This narrow focus means that the exams taken across the country address and assess health and public safety, including infection control, in a very similar manner. While there is variance in education requirements across the states, there is not variance in the exams that are required for licensure. Currently, to move to Nevada as a licensee from another state, you must complete an application and pay a non-refundable fee of $325. You must also provide a passport photo, an active license from another state, and sign up for a law class that is only offered on Tuesdays and Wednesdays in Las Vegas and Tuesday, Wednesday, and Thursday in Reno. In addition, each state which you hold a license must complete a form confirming you have a license in good standing from that state. In many states, this proof of good standing form can take months to be sent, something that neither the state of Nevada, nor Nevada can expedite. So while these lengthy delays are the responsibility of the previous state's regulatory office, it still creates a situation where someone needed to work is unable to, something employers in Nevada struggle with often. If the compact were passed, you would enact the only form of licensed mobility that is bidirectional and is considered the gold standard for mobility by the military. Finally, it is the only form of mobility that would benefit your actual constituents, allowing them the same benefits you currently give to licensees entering your state. While no state likes their citizens to leave, there are simply times where it must happen. And in this compact, it would benefit those residents tremendously. While some of the benefits are obvious for licensees, including the military spouse and even the state, by reducing reciprocity processing and providing a licensure database, some of the other potential beneficiaries may not be so obvious, but are equally important. We have heard extensive testimony in other states about the very real benefits to survivors of domestic violence and licensees displaced by natural disasters. For survivors of domestic violence, the ability to move quickly and anonymously may be life-saving. And in this industry, which is 85% female, the compact would provide the ability to work today and with tips have money in their pocket tonight, which can provide for groceries, a meal, or even a hotel while they get on their feet. In addition, as we have seen lately, natural disasters such as Hurricane Helena and the current California wildfires create a displacement of people who need to work and may have resources like family in your state where they can move and not only begin working, but also fill vacancies that currently exist. In the interim, I did reach out to your board and was told that they were neutral. I will be presenting to them on the 24th to get to educate them on what we're trying to do here and get more input. But the compact approach to license mobility provides clear benefits to licensees moving to your state, businesses in your state, and even the state itself, but most importantly to your constituents. Thank you, and I'm available to answer any questions.
Thank you, Assemblymember Torres Fawcett. And I know that Ms. Rosti had indicated that the Cosmetology Board had indicated that they were neutral during the interim. Last week, they reached out to let me know that they may not be neutral today. So I just want you all to know that we did do that work during the interim, and it was that we had been previously notified that they would be neutral, but I believe that they may have changed. So we look forward to Ms. Rosti presenting to their meeting in the next week or so to gain their support. At this time, I would like to provide a summary of the Articles of the Compact. Article 1 outlines the purpose of the Compact. Article 2 defines key terms and concepts used throughout the Compact. Article 3 establishes the foundational requirements for states to be eligible to join the Compact and details what is required for Compact member states to remain compliant. Article 4 describes the requirements for cosmetologists to participate in the Compact. Article 5 allows multi-state licensees who move to another Compact member state to apply for expedited transfer of their multi-state license to the new home state without the need for repeated primary source verification. Article 6 describes the authority for the Cosmetology Compact Commission and member state licensing authorities. Article 7 clarifies that only a licensee's home state may take adverse action against a multi-state license. However, a remote state may take adverse action against the licensee's authorization to practice in that state and may issue enforceable subpoenas for witnesses and evidence from other member states. Article 8 allows an active military member or their spouse to designate a home state where the individual has a current license in good standing. Article 9 outlines the composition and powers of the Compact Commission and Executive Committee. Article 10 requires the sharing of licensee information by all member states. Article 11 provides that rules carry the force of law in all member states. Article 12 ensures compliance with the compact by member states and details the procedures to be followed if a member state fails to comply with the compact. Article 13 specifies that the compact takes effect on the date of enactment by the seventh state. Article 14 provides the compact should be liberally construed to effectuate its purposes. And Article 15 maintains consistent effects in any law, statute, regulations, or other legal requirements in a member state that conflict with the compact or superseded to the extent of the compact. At this time, we are ready for any questions.
Thank you for your presentation this afternoon. Before I pass for questions, I just want to confirm one thing. Did you state earlier that there are 8 other states that have already entered into the compact, so we would be the 9th if this legislation was passed?
Mr. Buckhouse, I think you might be available on Zoom. Thank you.
Yes, that's correct, Chair. There are currently 8 member states in the Cosmetology Licensure Compact, and the Commission had its inaugural Commission meeting in October of 2024.
Great, thank you. And just want to confirm that there are 13 states that have introduced legislation to enter the compact.
That's correct. Yes, thank you.
Thank you. Committee members. Vice Chair Howdigi.
Thank you. Thank you, Madam Chair. And thank you for asking that. That was actually my questions. I know that the compact was going to be enacted when 7 states joined, and it sounds like there's 8, so it's official now. Do you have a list of those states that you can send us? You don't need to provide it now, but if you could send it over to us, that would be great. And I just have one question based off the bill we heard last Friday, where the compact, thank you, Madam Chair, where the compact So they charge a fee, right? The organizational national org charges a fee when somebody requests the license to transfer to another state. Does this compact also charge that fee?
So the compact will, I apologize. Is this question directed to
Assemblymember Torres
Chair,
Fawcett, for the
or-
record. Yes, please proceed, but you just don't forget to state your name for the record.
Apologies. This is Keith Blackout. I am policy analyst with the Council of State Governments. You're asking the compact authorizes each state to charge a licensure fee for the multi-state license, but it also authorizes the commission to charge basically membership fees that are basically a portion of a multi-state license fee would be needed to be transferred to the commission as part of the revenue sharing agreement to basically ensure that the commission has the operating resources or the financial resources that needs to operate. That's obviously the commission tries to keep that as a bare minimum, but the commission does authorize fees for licensees and for states that are members as well.
Committee members, any additional questions? Assemblymember Cole.
So my question is, I guess, related maybe to defining the term cosmetologist, like just looking at comparisons of different states. They have cosmetology, barber, esthetician, electrologist, instructor, nail technician. So this is just cosmetology, and so the scope of practice is going to be limited to that.
Thank you. Assemblymember Torres Fawcett, for the record, this is actually a conversation that I had with Mr. Buckout last week as well. If you could just help provide some of that clarification, because if this does provide a range of services, it would include like hairstylists and your nail techs and things like that. But if you could give some more clarification, thank you.
Hi, so again, this is Keith Buckout. I'm a policy analyst at the Council of State Governments. Thank you, Assemblymember Torres Fawcett, and thank you, Assemblymember, for your question. To answer your question specifically, the compact applies exclusively and explicitly to licensed cosmetologists, as the definition for cosmetologist in the compact model legislation itself directs each state basically within Nevada's current jurisdictional boundaries. Their current definition and scope of practice would apply. So each state retains sovereignty over its scope of practice for a cosmetology license and defines what that scope of practice is. So a multi-state licensee from another state coming to work in Nevada as under the compact would have to abide by Nevada's defined how Nevada defines a cosmetologist and its scope of practice. To answer your question about what other sort of beauty industry professions are included, unfortunately, the cosmetology licensure compact is limited just to cosmetologists, but as part of our cooperative agreement with the Department of Defense, Council of State Governments is facilitating the development of a compact for estheticians, and we hope to engage with the beauty industry further to develop further occupational licensure compacts for the other licensed beauty industry professions.
Committee members, any additional questions? Assemblymember Monroe Moreno.
Thank you, Madam Chair. I was just looking at the individual application from the state, and at the bottom, number 5, it has cosmetologist and a hair designer. And this is stupid, but what's the difference between the two?
I can answer that question. This is Leslie Rossi with FBIC. And the difference would be that the hair designer is specific to hair, where cosmetologists learn hair, skin, and nails. That's sort of an umbrella license for all three types of work.
Thank you, Madam Chair.
Mm-hmm.
Members, any additional questions? I don't see any. So before we go to support testimony, I just want everyone to know that I will be limiting testimony for all three bills today. We will do 30 minutes in Carson City, 30 minutes in Las Vegas, and 30 minutes on the phone. And so with that, is there anyone here in Carson City that wishes to testify in support to Assembly Bill 371?
Good afternoon, Chair Marzola and members of the committee. For the record, Amy Sjogren, that's S-H-O-G-R-E-N, with Black and Wadhams on behalf of the Vegas Chamber, here in support of AB 371. The Chamber has a long history of supporting compacts. We view the bill as a modernization bill and appreciate the sponsor for bringing this bill forward. Thank you.
Is there anyone else in Carson City wishing to testify in support? I don't see any. There we go. Is there anyone in Las Vegas wishing to testify in support to Assembly Bill 371? I don't see anyone coming up. Broadcast, is there anyone on the line?
To testify in support to Assembly Bill 371, please press star 9 to take your place in the queue.
Good afternoon, Chairwoman Marzola, Vice Chairwoman Habigui, and members of the committee. My name is Kelly Mae Douglas with the Defense State Liaison Office. On behalf of the U.S. Department of Defense and military families stationed in Nevada, I'm here to express support of the policy changes expressed in AB 371, a measure to enact the Interstate Cosmetology Compact in the state. State policies enacting interstate licensure compacts, such as the Cosmetology Compact, facilitate greater career sustainability for military spouses, improving their family's financial security and overall well-being. The Defense Department is grateful for the tremendous efforts that Nevada has historically taken to support our military families. Thank you.
Chair, the public lines are open and working, but there are no more callers choosing to testify in support at this time.
Thank you. We will move to testimony in opposition. Is there anyone here in Carson City wishing to testify in opposition to Assembly Bill 371? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition? Broadcast, is there anyone on the line?
Testify in opposition to Assembly Bill 371, please press star 9 to take your place in the queue. Chair, we have no callers choosing to testify in opposition at this time.
Thank you. We will move to neutral testimony. Is there anyone here in Las Vegas wishing to testify in neutral to Assembly Bill 371? I don't see anyone. I see 3 already in Las Vegas. You may begin when you're ready. Please remember to state and spell your name for the record. You each have 2 minutes.
Good afternoon, Madam Chair, Vice Chair Howdy, and committee members. My name is Stephen McDonald. I'm the Nevada State Board of Cosmetology Executive Director. I actually did come up for opposition, but I got kind of passed up a little bit. Stephen McDonald, S-T-E-V-E-N, McDonald, M-C-D-O-N-A-L-D.
Just to interrupt you for 1 second. So are you coming in opposition?
Yes, ma'am.
Okay, we'll go ahead and go back to opposition. You may begin when you're ready.
Thank you, Madam Chair. Right next to me, I have Janie Huggins, our Chief Compliance Officer, J-A-N-I-E Huggins, H-U-G-G-I-N-S. And to her right is Lauren Gossage, our Regulatory Compliance Specialist, L-A-U-R-E-N, Gossage, G-O-S-S-S-A-G-E. If I may, Madam Chair, the reason why we're coming in opposition is because our board voted initially to oppose this bill. As Leslie Rosti and her colleague from CSG has already stated, and especially Assemblymember Fawcett, Torres Fawcett, said that the board's going to hear their presentation on Monday, a week from today, and they'll be able to ask them questions, deliberate, and vote at that time. To the board, it appeared to us to be more of reciprocity, which we're already doing under our statutes, NRS 644-460 and NRS 622.520, and that's for all of our licenses, not just for the cosmetology license. As was stated, we have 9 licenses and 2 registrations, so we do that for every one of them. And since the cosmetology compact, it was mainly meant for active service members, we process those within 2 days. Just as an example, today, an applicant filed on Thursday of last week, the 13th. She took the Nevada law exam, which she scored 100 on, took it on Saturday. It's her choice when she wants to take the exam. And she had her license this morning. She picked it up at 8 o'clock this morning, and she's from Michigan. So that's reciprocity. So we do that very, very well and very fast. We're glad to say that. We are not opposed to the reciprocity, because that's what it looks like to us. But we wanted to make sure that the committee members knew that we process these things really easy. And also, as an aside, I'm an Army brat, so my dad was in the military for 23 years. So we moved around, lived in Germany and all that kind of stuff. So we definitely appreciate the service members.
Thank you. You may begin when you're ready. Is everyone testifying who's sitting at the table?
No, ma'am. We're just here now just for questions if the committee members may have some.
I don't think we have any questions, and if they do, they can take it offline. Thank you so much for coming today.
All right. Thank you, Madam Chair and committee members.
We will move to neutral testimony again. Is there anyone here in Las Vegas wishing to testify in neutral to Assembly Bill 371? Are you walking for us or? Oh, okay. Is there anyone in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
Testify in neutral to Assembly Bill 371. Please press star 9 or raise your hand in the Zoom window to take your place in the queue. Chair, we have no callers choosing to testify in neutral.
Thank you, Assemblymember. I will now close the hearing on Assembly Bill 371. I will now open the hearing on Assembly Bill 250. This measure revises provisions relating to certain debt. Welcome, Assemblymember. I believe this is your first presentation in Commerce.
It is. Thank you so much.
You may begin when you're ready.
Thank you, Chair Marzola and the members of the committee. I'm Heather Goulding. I represent Assembly District 27. Today, we are presenting Assembly Bill 250 to help victim survivors escape debt forced on them by their abusers. Domestic violence isn't just physical. It can also be financial. Studies show that 99% of domestic violence survivors experience economic abuse, and more than 3/4 of women facing financial abuse cite it as a major barrier to leaving their abuser. AB 250 gives victim survivors a path to break free from this control. Today, I'm joined by Serena Evans from the Nevada Coalition to End Domestic and Sexual Violence, and Peter Aldis is in Las Vegas from the Legal Aid Center of Southern Nevada. As experts in the field, they will explain the need for this legislation and walk you through the bill and the proposed amendment.
Good afternoon, Chair and members of the committee. For the record, my name is Serena Evans, S-E-R-E-N-A-E-V-A-N-S, and I am the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. It's an honor to be here today to help present AB 250, a bill that will have profound impact for victim survivors in our community. In abusive relationships, perpetrators use various tactics to control their partners. This can include physical, emotional, psychological, and economic abuse. Economic abuse systemically restricts a victim's financial autonomy and freedom, and coerced debt, a specific facet of economic abuse, is any non-consensual credit-related transaction incurred through threats, manipulations, force, and fraud. At its core, economic abuse and coerced debt are harmful, often causing financial devastation that traumatizes and burdens victim survivors long after they leave the abusive relationship, or forcing them to stay and risk future violence. In fact, the number one reason why victim survivors do not leave these abusive relationships is that they simply cannot afford it and have no financial security. There is no safety without economic security. That was weird. Is it on now? Okay, sorry about that. Once a victim survivor makes the decision to leave, they need to seek new housing, find childcare, set up utilities in their name, seek legal protections from an abusive partner, and sometimes go through lengthy and costly legal proceedings to finalize divorces and child custody agreements. None of this is possible without a good credit score, finances to fall back on, or affordable credit options. Because consumer reports are so routinely used by creditors, employers, and landlords, coerced debt has an economic ripple effect and impacts every aspect of a victim survivor's safety and well-being. The concept of coerced debt is not new. In fact, in the 2022 Violence Against Women Act reauthorization, the definition of domestic violence was expanded to include economic abuse and coerced debt. Due to the increased focus on this issue, there is strong data that highlights the dangerous and devastating impacts that coerced debt has. In a nationwide study, 99% of survivors reported experiencing economic abuse, and 52% of domestic violence survivors had coerced or fraudulent debt, with 46% reporting credit damage. Survivors with coerced debt are 2.5 times more likely to stay because of economic dependency. The average amount of coerced debt is $15,936. A 2020 survey of survivors reported that 2 in 3 survivors discovered debt, or coerced debt, only after directly receiving a bill or being contacted by a debt collector. Another 25% of survivors say that they found out about the debt by accidentally seeing or finding a bill or other mail that was not directly sent to them. By the time unpaid debts are discovered, survivors may have already have consumer debt judgments that lead to wage garnishment and bank account restraint. Despite knowing the impacts of coerced debt and the harm that it causes, there is currently no remedies for victim survivors of coerced debt, which essentially forces them to carry the burden of their victimization and only further penalizes them. Chair, with your permission, I would like to read a statement from a victim survivor of coerced debt who cannot be here today. Thank you so much. My name is Elizabeth Kenny, and I am a 44-year-old health professional working single mother of 2 children, Isabella and Vivian. I left my abusive marriage for a multitude of reasons, including emotional abuse, physical abuse, verbal abuse, embarrassment, and exhaustion. I will overcome most of the abuse. However, the financial abuse will continue for years to come, and it continues to suppress my daughters and me. At the beginning of the 3.5-year marriage, I was pressured into buying a business the first week I went back to working full-time after a 6-week maternity leave. I wasn't sleeping and was struggling with breastfeeding the baby. I was vulnerable, and I didn't want to buy the business because it meant my husband at the time would stop working as a high school teacher, which brought in some income from our mortgage and childcare. In exchange to running the business he wasn't trained to do. He was never home. He was gone for 9 straight nights. He was once gone for 9 straight nights while I was 8 months pregnant with the second child and working 60-hour weeks with a 1-year-old. He continued to pressure me to sign more loans in my name, since I had the credit score to do so, and pour into the business. One business loan is dated November 2nd, 2021. The day I was in active labor with our second child. I don't remember signing that, and now realize that he forged my signature on many loans. He racked up our credit cards and bought a new truck the day we bought the business. I now realize that was financial abuse. The aftermath continues to this day. After a 2.5-year-long divorce, due to my ex-husband not participating in the divorce, I had to pay him to keep the house that I had already bought during the marriage. But I did get to keep my children and I safe. He was angry and still is angry that I chose to stop all the abuse and leave the marriage. I am now stuck with over $600K in credit card debt, over $100K in business loans, and over $130K in legal fees. And he continues to serve me legally, asking to reduce his child support, which continues to cost legal fees with money that I just don't have. I now have a credit score of 490. I didn't know a credit score could get so low. So I can't even go rent a home or seek financial services if I need to. I am financially ruined and focus on making my mortgage and paying the bills on one income. He has not paid one dime for the children since July of 2022, the month I filed for divorce. I will recover over time, but the state and the laws do nothing to protect people like me in my situation. This story is sadly just one of many. The proposed policy before you would offer a critical relief mechanism to our most vulnerable and at-risk Nevadans. Additionally, legislation like this has the opportunity to strengthen Nevada's economy by decreasing long-term reliance on public benefits, shelter, and social service programs. By passing AB 250, Nevada would get to join the growing national movement to ensure economic justice for victim survivors of domestic violence. Other states who have passed similar legislation include Minnesota, Texas, Maine, Connecticut, and California, with legislation currently pending in Vermont, Massachusetts, Illinois, Colorado, and New York. The adoption of this legislation would send a clear message that domestic violence is never the fault of the victim survivor and that their safety and healing is paramount.
At this time, we'd like to pass the microphone over to Peter Aldis in Las Vegas to go through the bill.
Thank you, Assembly Member, and thank you, Chair Marzola, members of the committee. For the record, my name is Peter Aldis. I'm a staff attorney at Legal Aid Center of Southern Nevada, and my practice focuses on helping low-income Nevadans deal with debt. I'm going to briefly talk about the need for this bill from the legal context, and then I'll walk through the bill and the proposed conceptual amendment. Unfortunately, survivors of domestic violence and other victims of economic abuse lack meaningful legal options to try to rebuild their lives. In theory, debt collections based on breach of contract law and contracts that were not entered into voluntarily are not enforceable. But in practice, there are few opportunities for victims to assert their rights. Unlike in the criminal context, there is no civil right to counsel, which means that the vast majority of defendants in debt collection cases do not have an attorney, and they have to navigate the legal system on their own. Many are overwhelmed and just give up. When victims are able to figure out what forms to file in order to have their day in court, they are often not aware of the relevant legal standards and are not able to gather admissible evidence to support their claims, which means in the vast majority of cases, judges rule against them, ruling that the victim couldn't prove that they didn't owe the debt. Court judgments aren't the only issue facing victims. Not every unpaid debt results in a lawsuit, but almost all have an impact on the debtor's credit score. Under the Fair Credit Reporting Act, victims can dispute this derogatory reporting, but consumer reporting agencies usually just pass that back along to the furnisher that provided the information, who obviously has no way to determine whether the dispute is valid. And as a result, almost all disputes filed by victims in these circumstances result in a determination that the victim actually owes the money, and so that negative reporting remains on the credit report. And as Serena just explained, having that bad credit impacts many aspects of these victim survivors' lives, and everything from the cost of borrowing money, getting a car, the ability to rent or buy a home. And even when these victim survivors come to me, my options are limited. Many times, all I can do is to place them into a bankruptcy because it's the only effective way to resolve the debt. And while bankruptcy does resolve the debt, it has many very serious consequences, long-term impacts on credit, and also you can only file bankruptcy, at least Chapter 7, the most common kind, once every 8 years. So this limits their opportunity to resolve other debt issues through the same mechanism. At the end of the day, it isn't fair to burden victims with these consequences on top of everything else that they've been through. And that's the basic principle at the heart of AB 250. So I'll now go through the bill and explain how it works. Broadly speaking, the bill has two parts, one targeting debt collection and one focused on credit reporting. Section 1 is the debt collection portion. It begins by establishing the protections available to victims of coerced debt and economic abuse. Those protections include stopping any attempt to collect the debt and prohibiting the creditor from selling or transferring the debt so that the debt can be collected later. In order to trigger these protections, the victim must provide a notice to the creditor that's attempting to collect that debt, along with some supporting documentation like a police report. That notice must include a description of the debt, information about how the debt was incurred, if the victim knows those details, because like we've mentioned, sometimes they're not aware of the debt until much later, and contact information so the creditor can follow up with any questions. Section 1 also includes a process so the creditors can get more information and a dispute process if they believe that the debt was not coerced or the result of economic abuse. Section 1 makes it clear that creditors can pursue the perpetrator in these cases to collect the debt, so the creditors do still have a remedy. Section 2 relates to credit reporting. Using the same definitions as Section 1, this portion of the bill provides a mechanism for victims to notify consumer reporting agencies that all or part of a debt is the result of a coerced debt or economic abuse. The required elements of the notice are essentially the same as the requirements in Section 1, and again, documentation is required. Section 2 also sets out how the reporting agency must respond to that notice, including a requirement that the reporting agency conduct an investigation. Should that investigation determine that the debt was a coerced debt or the result of economic abuse, Section 2 requires the reporting agency to remove the debt from its files. If the investigation determines that the debt was not a coerced debt or the result of economic abuse, the reporting agency has to notify the consumer before continuing to report that debt. As part of the process of coming up with this legislation, we've been listening to stakeholders, and we did work on the conceptual amendment, a copy which hopefully was shared with the committee. That amendment does add a new co-sponsor. It clarifies a lot of definitions, including the definition of creditor, coerced debt, and qualified third party. In addition, several categories of debt are specifically carved out so that the bill is more narrowly tailored. And then finally, the amendment gives creditors a specific authority to get a court ruling so that they can pursue perpetrators and collect the debt. Thank you, members of the committee, for the chance to speak on this important issue.
Thank you, Ms. Evans and Mr. Aldis. The amendments we presented.
Can you remember to state your name, please?
Heather Goulding for the record. The amendments we presented reflect accommodations made in response to stakeholders' concerns. We look forward to continuing the dialogue with them and hope to find a resolution that addresses their concerns while also protecting victim survivors. With your permission, Chair, I'm now going to ask Jonathan Norman to join us to answer any questions that the committee members have.
Ready for questions? I have a couple questions, but if it is not answered with my colleagues' questions, Assemblymember Moore. Assemblymember Miller.
I was looking like, is she on this committee? Thank you so much, Chair. And thank you for bringing this issue forward. Typically, I think of financial abuse or the part of abuse that deals with finances with being cut off from access to credit or finances. But I understand how this happens often as well. My question is, and I do appreciate the amendment trying to, address some of the concerns and tighten it up, but I guess I'm still unclear with how does one prove that this has been the result of an abusive relationship or tactics? And maybe if you could just share with some of the other states that have passed these laws, how in terms it's investigated or, and I don't want to put the burden of proof on the victim, but if you could expand on that, please.
This is Jonathan Norman, JONATHAN-NORMAN, with the Nevada Coalition of Legal Service Providers. So in the bill, when the victim provides, think of it as a shield to the debt collection. So the victim has a police report or some documentary evidence. They provide that to the debt collector, and then that creates a shield that stops that collection. It is then incumbent upon the debt collector or the creditor to say, we think you were there and signed, and that is your debt, and then it's incumbent upon them to bring an action in court. So the victim of the abuse has to have some documentary evidence and has to provide in writing to the creditor that this is a coerced debt or from economic abuse. And I don't know if Mr. Aldous has anything to add there.
Thank you, Peter Aldous, for the record. I think that really summarizes the way that this process is intended to work, which is that it is merely advising the creditor that this debt was the result of its coerced debt or economic abuse and providing sufficient documentation. At that point, it is incumbent on the creditor to take any further steps.
I will wait right now. Thank you, Chair.
Vice Chair Howdigy.
Thank you. And I have a question, follow up on my colleagues on that documentary evidence. I know that one of the forms you said is like filing a police report on, I think it's section 110A, where it says a police report can be one of the documentations, but can they not file a police report now? Because I know, for example, like fraud and identity theft are already a crime. Like we don't need this bill. Those are already a crime, right? Like they can already report that to the police department and then file that with the credit bureaus and the creditor. But for coerced debt, is that not an existing crime? Like if someone was just the victim of coerced debt from an abusive relationship, can they not already go to the police department to file a police report for that? And
I think Pete Aldous is the best person to answer that one.
Thank you. Peter Aldous, for the record. Yes, absolutely, you can file a police report, and hopefully that starts some kind of investigative process that results in criminal penalties for the perpetrator. But that's not the intent of this bill. This bill is intended to address the economic consequences. Is it possible that restitution, if the higher burden of a criminal prosecution eventually comes into play, will also make the victim survivor whole? It's possible, but in a lot of cases, that's not what happens. There is no firm investigation. This isn't like a violent crime necessarily. I mean, a lot of times it is, but sometimes it's not. And so as the issue becomes less about the criminal consequences and more about how do we protect these victims and let them move on from this horrible thing that happened to them, that the purpose of purpose of this legislation is to give them a civil shield, as Jonathan said, to let them speak up for themselves, whether or not the police determine it's an important enough issue to investigate, whether they can convince a jury of their peers that this abuse happened.
okay, thank you. And I think that like kind of answers my question. And that was what I was trying to figure out was if they file a police report, is that enough to take to the creditors and the credit bureau? Like if they file it despite whether the police investigated it or not, like so they without a police investigation, then it's not enough simply filing a police report to take to the creditor or the credit bureaus.
Jonathan Norman.
For the record, I'm sorry. Mm-hmm. Yes. In this case, it is sufficient to file the police report, which would be a crime if you were doing that fraudulently. And I don't think that there's a big risk that a lot of people are going to start fraudulently filing police reports in this situation. But yes, it is sufficient to file the police report to make the statement that this debt is the result of coercion or it is the result of economic abuse. And that then shifts the burden to the creditor to determine whether or not they want to take any further action or just stop collecting the debt.
Assemblymember Cole.
Hello. Thank you for bringing this. I think it's a very important issue, and I'm glad to hear that other states are looking at it. In just looking at briefly the Texas the way that they approached it was making it more specific that it is a crime for this coerced debt. So it's more than just identity theft. It's a little bit different than that. So my question, I guess, is, and I have a friend who suffered from this, so I do understand it on a personal level. But the creditor has not done anything wrong either. So is it appropriate for us to put all of the burden to fix the problem on the creditors? Because I think right now our interest rates are extremely high already. And if we have so much debt that ends up not being paid, because I think that's what the result will be. I don't picture this actually being paid back by the perpetrator. I know that's part of the intent, but I don't see that happening. So I guess that's where my concern is. Do you feel that it's fair to put the burden on the creditor? And then, Mr. Norman, you had mentioned that the requirement is for a police report to be filed with the creditor as part of the documentation. Can you point to the specific spot in the bill that has that? Thank you.
Jonathan Norman, for the record. By the victim, one of the documentary evidence can be the police report. It does not have to be the police report. If I made it so that it had to be the police report, I misspoke. So that's in, sorry, I'm scrolling up, Section 1, subsection 10. And that has several, so it has adequate documentation includes without limitation, and then the first one is the police report, and then it has a few other.
And Serena Evans, for the record, if I may piggyback off that. So police report is just one of 3 accepted forms of documentation. So police report, an issuing a court ruling, and or an affidavit signed by a certified third party. And I do want to note that we use certified third party police report and or finding from a court in other areas of statute for victim survivors seeking relief and support. So for lease break agreements, employment protections, those are other areas that we see this being used.
Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. I just want to make sure I'm fully understanding. So my understanding is that currently if a victim survivor has been the victim of coercive debt and they are brought to court already by a creditor, this allows them to put a stop to that and it shifts the burden then, is that correct?
Jonathan Norman, for the record, yes, that's correct. So this serves as a shield that stops collection efforts and shifts the burden to the creditor, and they can decide if they want to pursue action that will overcome the burden that this was not a coerced debt, and that is shifted.
May I have a follow-up, Chair? Go ahead. And so are we seeing now the defense of coercive debt being raised currently in collection cases? Is that something that we see now?
I'll defer that to my colleague, Mr. Aldous.
Thank you, Peter Aldous. For the record, it certainly has been a defense. It has not frequently been a successful defense. The reality of what usually happens in these cases is there is a summary judgment motion, assuming that the victim survivor files an answer. And at that point, the judge usually only has a few questions. Is this your name on the bill? And are you going to, why can you not pay it? Because the defense is, much more nuanced. So unfortunately, it hasn't always been a successful defense. I'm sure there's cases where it has, but I haven't seen it.
Did that answer your question? Assemblymember Kasama.
Thank you, Chair. And this is certainly such a tragic reality that many people are facing. My question has to do with Section 1. Let's see, 1A3, where it has return any payment that has been made. So I'm trying to think of how that would work. I'm in property management, so if somebody's had to pay the rent and maybe they shouldn't have, and it was paid via credit card or something like that. And now I've collected that, and because this is a reality, let's say I have two owners on a property, so now I've taken that and I've paid the owners and split the payment up. How am I going to get that payment back from an owner when he was due the money? Again, he's out the money, so he's not going to send the money back to me. And then am I, the property management who is basically providing services, responsible now for returning that payment? Or who's going to return the payment, and who's going to force the collection of the payment? Let's say in my example, the owners don't want to pay it back because they were due rent. So who do you go after, and who's going to go after, and are they going to be penalized because they feel, I'm sure they're not going to return it because they had rent that was due. How would this work?
Jonathan Norman, for the record, I'll take a first stab at the question and then see if Pete has thoughts. So Section 1, Subsection 3, return any payment made by the debtor on the debt, including without limitation, any payment executed through a writ of garnishment. I think in my mind, and maybe we can craft that to be narrower, that would be in the specific context of a collections action. So where there has been a garnishment of wages or a execution on a bank account, those are the types of scenarios I had thought of it. And if we can narrow that up so it doesn't have kind of the innocent, property manager who's already distributed that money, I think that's something that's worth taking a look at. Pete, I don't know if you had any thoughts on that question.
The only other, Peter Aldis for the record. The only other thing I would point out is that I think in every case there's going to be a creditor who would like to be made whole. That in no case are we blaming the creditor, whether it's a property manager, a landlord, a credit card company, etc. We've certainly, in working with stakeholders, tried to narrow the scope of this law. But at the end of the day, somebody is not going to get everything that they're owed as a result of this law. As I had mentioned earlier in my testimony, frequently the solution that I have for people that come to me with these problems is bankruptcy. And in that case, the creditor still doesn't get their money. And in some cases, money that was paid to a creditor has to be returned. Somebody has to bear the burden, and I don't want to minimize the cost that has on everybody. I think our goal with this legislation is to try to minimize the impact on the victim survivor of this sort of coerced debt.
Assemblymember Torres Fawcett.
Thank you, Chair, and thank you for this piece of legislation. I had a question just about the process. So if an individual were to go to a bank and say that, this amount was not appropriately charged, or, this was, and it was this coercive debt situation, then, and if the bank says it rejects that petition, what would happen? Can you walk me through what that process looks like?
I'm going to defer that to Mr. Aldous.
Thank you, Peter Aldis, for the record. Yes, at that point, it isn't necessarily much different than if the bank wanted to collect the debt under ordinary means, in that they have to file a lawsuit, and they need to specifically, and there's procedures for that in the bill, but they need to specifically assert that this is not, in fact, the result, that this debt is not coerced. It's not the result of economic abuse. And to the extent that they can prove that to the judge, then they can collect the debt just like any other debt.
I guess I just have a concern that I'm willing to work with you all on, but I just am concerned that, that realistically a woman that has experienced this type of hardship is not going to be able to have a lawyer and fight their case against the lawyers for big banks here in the United States. So my concern would be that in every case, the individual would lose to in the court process, and that it's just unnecessary. We're creating a bigger hardship. So I would like to see that addressed. Thank you.
Assembly Member Miller.
Thank you so much, Chair. Another question I have, as we're referring to creditors and collections, there's a number of items that appear on our credit report that's not necessarily a loan, and in the same essence that I'm interpreting this bill. So, for instance, you know, a loan, any type of credit is one thing, but what about other things that would hit my credit report that could go into collections, such as utilities? Would that fall under this bill as well, that if utilities were put in the victim's name, where they could state that that was a part of coercion, and then what would be the, I'll leave it there.
Peter Aldis on behalf, or for the record. At the end of the day, any obligation to pay is a debt, whether it's the obligation to pay utilities, whether it's to pay for money that you've borrowed. The intent of this bill is to specifically deal with debts like credit cards. But if, in fact, you owed utility bills, at some point the utility company is likely to put that on your credit report because that is a debt that you owe. And in many cases, they have the right to sue. In other cases, they don't. But certain utilities do file quite a bit of lawsuits in order to collect their debt. And they're relying on that same basic principle of if you owe money under a contract, you have a right to collect it. So that I don't know that that's the main aim of the goal of this bill, to get things like utility bills off people's credit. But I don't know that it is impossible for that to happen under the way the bill is currently written.
Chair, may I clarify? Thank you. And again, I'm not taking it as to get things off someone's credit, as much as I'm seeking to see what could be defined as coercive debt, what would fall under that definition.
And Peter Aldis, for the record, the definition in the original bill was as kind of intended to be broad, to capture a large number of things. And I think that as we've worked with stakeholders, that definition has become more narrow. And again, I think that under my interpretation, certainly a past due utility bill would fit into the category, because the definition really has a lot more to do with how the debt was incurred. I think that it's a little hard to argue in a lot of cases that you don't need utilities. And so that's why I don't think of that particular type of obligation as being what this bill is targeting, as much as discretionary borrowing. So borrowing on a credit card. Like we heard all the examples from the story that Serena told. And in those cases, whether, again, what's in the credit report or there's a lawsuit, this is something that someone else forced you to take out, that it was not a result of your knowing, willing choice to borrow money. And that's why the bill is intended to protect those victims so that they are not stuck with the bills long after the other abuse hopefully has ended.
Committee members, any additional questions? Assembly Member Urick.
Thank you, Chair. And boy, I think like my colleagues hearing the story, Ms. Evans, about how this occurs is just atrocious. And so I also applaud effort to address this issue. But there's, and I'm going to tail on a question that my colleague had asked, Assemblymember Cole, that I don't think we got that. And so I want to just kind of push on that and ask and see if we can get clarification, because there's a lot happening here. And as I look at the bill as initially written and then with the amendment, it looks like it permits creditors to investigate claims that, by the way, under, I think it was subsection 1(3)(a), even an oral statement to a creditor that this is the product of coerced debt or economic abuse is going to be sufficient to accomplish what you refer to as this significant burden shift, right? So they can, now they have a right to investigate that, seek clarification, and push for more. And ultimately, if they can't come to the right thing, they can seek judicial remedies, and bankruptcy is, I guess, an example that's been already given as something that creditors currently do. And then your amendment seems to also clarify that they can go after the abuser or the coercer to chase them for the credit. So I appreciate that aspect of it. But my question is, with all of that happening, and given the challenges that I think we can anticipate in locating, recovering funds from abusers who are very likely to be uncooperative, financially insolvent, or legally evasive, how do we ensure with this burden shift that we're not just leaving the complete financial burden of all of this now on these creditors, right? And basically leaving them to bear the full financial loss of these circumstances. And then, again, what my colleague asked, is that going to maybe result in some very high interest rates now that could create even a larger problem? So can you maybe address that for me?
Yeah, Jonathan Norman for the record. I did have a little Post-it note for you. That was passed to me after we had moved to another question. So I think it is, and Mr. Aldos mentioned this a little about, not everybody is going to be made whole in this moment, right? But we have a victim who's fleeing domestic violence, and then we've tried to put in protections to make sure there's some veracity to that claim. And certainly if there's a way to tighten that up so that you don't have the possibility of people fraudulently making this claim, I think we the sponsor would be open to looking at that language. And so then if if Mr. Aldos, his only remedy is bankruptcy for those clients with all the consequences that has, and really the abuser, then there is no consequence for them, right? They're just moving on with their life. And so when we think about who is best equipped to hold that abuser accountable, I think it is probably not the victim. And there's a lot of reasons, even if the victim could, and Serena might be able to shed light on this, even if they could, they likely won't, right, pursue anything against their perpetrator. They're probably, if they're lucky enough that they got in a safe place, they're happy, and that's the win for them, and they're going to deal with this financial fallout however they can. And so as a public policy, when we're deciding who should have the to not be made whole, I think from our perspective, it shouldn't be the victim. And then the company is always free to pursue the perpetrator of that abuse. Is that a great answer that's satisfying? I think there is going to be somebody left out in this scenario, as Pete mentioned, and from our perspective, working with victims, it shouldn't be them.
Committee members, any additional questions? I don't see any. I do have a couple of questions. How many other states have passed such legislation, if you know?
Serena Evans for the record. So 5 so far have passed the legislation, and it's currently pending in 5 other states.
Thank you. I have another question on page 3. So it is section 1, subsection 3. It's probably more from my understanding on how this would work. It says the notice provided by a debtor to a creditor may be provided orally or in writing. So if the victim has to provide some sort of documentation to the creditor, I'm trying to figure out how this would work. Is it to where I would call the creditor, say this debt was due to economic abuse or coerced debt, and that process would start, and then the victim would submit something in writing?
Serena Evans for the record. Yes, that is the intent. So the oral notice could just kind of be to flag it, get the claim going, and then substantial proof and adequate documentation would need to be provided to prove the coercion.
Okay. So, and we can talk offline to maybe amend that a little bit. So if I'm a victim and I'm reading and I'm not into the legal field, right, I'm thinking, okay, I can do it orally or in writing, but which one is it, right? If I essentially would need to do both. Does that make sense?
Serena Evans for the record. Yes, it makes perfect sense. And I think we want this to be as victim-centered, trauma-informed. And so I don't want to speak for the bill sponsor, but I think we're open to all suggestions of how to make that language as clean and tight as possible.
Perfect. Thank you so much. And again, thank you for the presentation and bringing such an important bill. And we will move to testimony in support to Assembly Bill 250. Is there anyone here in Carson City that wishes to testify in support? Please remember, you have 2 minutes.
Good afternoon, Chair and Committee. My name is Marlene Lockhart, and I am representing as the past president or chair and board member the Domestic Violence Resource Center. We are in support of AB 250. We think it's a very important piece of legislation, and our organization in Northern Nevada is the largest wraparound domestic violence service center here. And one of the crowning services that we provide our members is financial stability and training and support. We have been wildly successful in training our clients and our victims in how to open a bank account for the very first time, how to pay off a payday loan, and so when they leave our program, that they are financially able to navigate the world and hopefully a road to sustainability. One of the major problems that we have is the coercive debt. We have examples where a spouse opened up credit online, opened up 9 different credit cards to a debt of over $12,000 that the victim was not aware of because he had access to her personal information and could do it digitally. We had another example where the abuser bought a vehicle for $13,000 in the name of the victim. So we have story after story where this is a huge issue. And we have had this last year in 2024, for the first time, we had our survivors, we had 3 different individuals buy a home for the first time. And we think that the more we can do to help them and provide another measure to get rid of the debt.
Can you wrap up your testimony,
yes,
please?
And we would be happy to work with the sponsor and the stakeholder group for any amendments. Thank you.
Hello, Chair Marzola and members of the committee. My name is Carissa Pierce, Carissa and I'm the Government Affairs Manager with Children's Advocacy Alliance. I am here in strong support of AB 250. While domestic violence may occur behind closed doors, its impact does not stay there. In Nevada, 1 in 2 women experience domestic violence, meaning hundreds of thousands of children are growing up in homes where violence is a very real reality. They feel this abuse mentally, emotionally, physically, and financially. They feel it when their parent is denied housing because of a ruined credit score. They feel it when coerced debt forces their family into poverty. And they feel the painful truth that oftentimes escaping means losing everything. Many survivors say their physical wounds heal over time, but the financial scars of abuse stay with them for decades. Right now, Nevada law offers no way for victims to remove coerced debt from their records, which means that we are forcing survivors and their children to bear the financial burden of their own abuse. AB 250 changes that by giving survivors a way to regain financial stability, rebuild their lives, and provide security for their children. It ensures that creditors and reporting agencies recognize coerced debt and stop collecting from the victim. This bill is about safety, dignity, and justice, and I urge you to support AB 250 and stand with Nevada's children and their families. Thank you.
Good afternoon.
Good afternoon, Madam Chair, members of the committee. For the record, my name is William Horn with Western Public Affairs, representing SafeNest. SafeNest is the largest provider of services to survivors of domestic violence and sexual assault. Here to provide support for AB 250, and SafeNest is supportive of any type of policies that will remove obstacles to survivors of domestic violence as they go on their journey for a better life and safety. I also like the idea that now we're discussing things that are outside typical realms of domestic violence, which people think of physical abuse, which certainly occurs, but you also have intimidation, you have threats on loved pets, and you have coercive debt. You have these very many different things that can come into a domestic violence relationship. And so this bill also aids in the discussion on that, so we can really get our minds around what domestic violence is and how it affects our community. And I'd like to lend SafeNest support in AB 250. Thank you, Madam Chair.
Thank you, Chair and committee members. My name is Nick Shepak, Nickshepak, and I am the Nevada State Director of the Fines and Fees Justice Center. While the Fines and Fees Justice Center focuses on financial penalties in the criminal justice system, unfortunately, we cannot decouple sexual and domestic violence and this type of coercion and the criminal justice system. Investigative report by Salon found that 77% of women in our local jails are victims of intimate partner violence. Many of their crimes that have landed them there are survival crimes directly related to financial abuse in an attempt to get money, or crimes that they were coerced to commit by the same abuser who is creating this coercive debt. We also know that financial stability is the number one key to keeping individuals out of the criminal justice system. And so this type of debt is a direct pipeline to engagement with the criminal legal system. And we believe that anything we can do to help these individuals will not only address this immediate financial issue, but will also alleviate some of the burden on our criminal legal system. Thank you.
Good afternoon, Chair and members of the committee. Tess Opferman here on behalf of the Nevada Women's Lobby. Perpetrators of domestic violence often use coerced debt to destroy a victim's financial security and credit. This traps victims in abusive relationships, increasing their risk of further violence. Those who manage to escape are often left with crushing debt that follows them for years. A nationwide study found that 99% of survivors of domestic violence experienced economic abuse. 46% reported credit damage. Without intervention, many victims struggle to secure stable housing, employment, or credit, keeping them trapped in the domestic violence cycle. Financial dependence is one of the biggest reasons victims stay in abusive relationships. By providing a path to financial relief, as AB 250 does, we empower victims to leave unsafe situations and rebuild their lives. For that, we are in support of AB 250.
Good afternoon, Chair and members of the committee. For the record, my name is Tara Webster, Tarawebster. I'm the policy manager with the Progressive Leadership Alliance of Nevada here in support of AB 250. Intimate partner abuse is more prevalent and severe among Black, Indigenous, and Latina women and can take the form of coercive control, which involves the systematic, and ongoing use of violence and intimidation, isolation, and control to limit a victim's freedom and autonomy. Credit damage from coerced debt can make it more difficult for women of color to leave their abusers if they aren't able to access loans, apply for housing, sign up for utilities, or open a bank account. But this issue doesn't just impact women, it impacts everyone, no matter their gender, race, or social class. It can come from the most unlikely places and faces. Coerced debt might look like a parent taking out credit cards in their children's names or forcing their child to take out student loans only to keep the funds. It might look like elder abuse. Victims of economic abuse often don't talk about their experience because of the shame and stigma. Plan believes that all individuals deserve economic independence to make financial choices for themselves, and we believe this bill offers the necessary legal protections to free victims from their abusers. We urge your support for AB 250.
Hi, my name is Andrew Clark. That is C as in cat, L as in lucky, A as in Assembly District 12, the best assembly district in all the assembly districts. That is R as in Ricky, K as in Kennedy, and E as in everyone, which Char Webster mentioned this bill will benefit everyone. We support this victim-centered solution to providing financial remedies for survivors. The solution will allow financial freedom for people in our community who need it the most as they work to rebuild their lives, and New Day Nevada is proud to be here in support. Thank you so much.
Hi, Chair, Assemblywoman Marzola and the committee. My name is Jane Grossman, Jane Grossman. I'm in strong support of this bill, and I ditto all of the comments that we've heard. Thank you.
Thank you for your testimony today. We will move to testimony in support in Las Vegas. You may begin when you're ready. Please remember to state and spell your name for the record.
Thank you, Madam Chair. My name is Renee, Renee. My last name is spelled Ruiz. I am representing National Nurses United, National Nurses Organizing Committee of Nevada. We are in support of AB 250. While we represent the interest of 3,000 RNs within the state of Nevada, unfortunately, some of our folks are victims in the case of financial abuse and other domestic abuse. And that we support it, but also many of our nurses see the fallout from domestic abuse in our hospitals and our emergency rooms. We are fully in support of SB 250. Thank you.
Thank you. Is there anyone else in Las Vegas wishing to testify in support? I don't see anyone. Broadcast, is there anyone on the line?
Testify in support for Assembly Bill 250. Please press star 9 to take your place in the queue.
Good afternoon, Chair. Oh, go ahead.
You may begin.
Thank you. Good afternoon, Chair and members of the committee. My name is Brianna Gallart, and I am a survivor of domestic violence and financial abuse. During the relationship, I didn't understand what was happening or how severe his coercion was impacting my life long term. At first, he'd request for assistance purchasing small necessities and gradually increased. Before I knew it, he was discussing loans with banking institutions and would not include me until a signature was needed. When I'd ask for information, he would ensure he was going to reimburse me after he received his paycheck and not to worry about the details. The reimbursement never came. Whenever I'd question why a purchase was necessary or express concern, I was told that's what good girlfriends do, and we're supposed to support one another. As the abuse progressed, I became the person that had to ask for money out of my own bank account, and he would hold my cards for safekeeping. This would lead to me having no money for food for days at a time while he travels with friends and swipes my card. Despite seeking help with the legal court system, this was not considered adequate documentation for the banking institution and still deemed me responsible for all incurred debt. This impacted my life not only mentally but financially. Over 6 years later, I still am unable to purchase a reliable vehicle for myself and my child without a cosigner due to my damaged credit score. This relief mechanism would mean so much to me and would change my life. This would make it possible to purchase a home, qualify for a credit card, and alleviate the unnecessary stress. Having this financial impact has led to me feeling as if I haven't escaped from his grasp and I'm still trapped under his control. I truly hope this relief mechanism could become a reality to set victims of violence free from their abusers and allow them the chance to start fresh and to heal. Thank you.
Thank you for sharing your story with us today. Broadcast, is there anyone else on the line?
Good afternoon. My name is Samantha Helms.
SAMANTHA-HELME. I am the Victim Services Coordinator for the Walker River Paiute Tribe. I am here today to express my strong support for the proposed AB 250 bill. As a representative of our community, I witnessed the profound and often devastating impact that domestic violence can have on individuals and families. Many of our victims have experienced significant financial hardship as a result of their abusive relationships. These challenges not only affect their immediate well-being, but also hinders their ability to rebuild their lives and at times keep them in their abusive relationships. The passage of this bill will provide critical resources and support for domestic violence survivors, enabling them to regain their financial independence and security during their recovery process. By addressing the economic barriers faced by these individuals, we can empower them to heal and move forward, instilling hope for a brighter future. We believe that supporting this bill is essential for fostering a safe and more supportive environment for all victims of domestic violence. Together, we can make a meaningful difference in the lives of those who have endured such trauma. Thank you so much for your time and have a good day.
Hello, my name is Marcia Pesnowski, and I'm a domestic violence advocate for Nevada Outreach No to Abuse in Nye County, Nevada. My name is spelled M-A-R-C-I-A, last name P-E-Z-N-O-W-S-K-I. Good afternoon, Chair Marzola and committee members, everyone. I would like to share the story of a client of mine with whom I've been working for the past 27 months as she tries to extricate her life from her abuser and start over. One of the challenges she continues to face is coerced debt. The man she lived with for many years took control of a credit card, which he actually applied for in her name without her knowledge or consent. He maintained a balance on the card, which was at or just above the credit limit of $10,000. There were almost always late fees incurred. He controlled the debit card to a checking account in her name at a separate bank. And as a final coup, he removed her name as managing partner to the limited liability corporation she had created for her own small business. When this client finally found the courage to ask for help and took steps to live independently, she found her credit rating in shreds, and then she saw the reasons why. Her income looked like it belonged to him. His debts appeared to be incurred by her. She currently finds herself in need of finding a new place for herself and her young son to live, but because of the coerced debt, she can't qualify as a tenant for an apartment or even for a loan. She's made reports on her perpetrator's activities to local law enforcement, the Nevada Attorney General's office, her bank, the credit card company, and Silver Flume, which, as you know, is the agency that regulates businesses in Nevada. It is very difficult to prove that it was her ex who did these things to her, but she has done an extraordinary job of record keeping. Our hope is that at least one of the avenues she has pursued will bring her some relief. If passed, AB 250 can do so much for clients like mine who face what seem like unrelenting financial pressures when they seek to start their lives over to protect themselves and their children. Please help them obtain justice and peace.
If you have just joined and would like to testify in support of Assembly Bill 250, please press star 9 or raise your hand in the Zoom window to take your place in the queue.
Good afternoon, Chair Marzola and committee members. My name is Lisa Lynn Chapman. That's L-I-S-A-L-Y-N-N. Last name is Chapman, C-H-A-P-M-A-N. I worked in the anti-violence advocacy field for 22 years with a focus on working with victims of domestic and sexual violence. During that time, I created and implemented financial literacy programs for victim survivors and advocates.
and a microloan program designed to assist victim survivors with emergency needs such as new tires, deposits on housing, etc. Currently, I provide expert witness services in Clark County, and I am an NCE DSB Public Policy Task Force member. In my experience, financial abuse is one of the most common and effective forms of abuse. Perpetrators often use coerced debt to deplete a victim survivor's economic security and credit score. Think about it. Credit is essential for obtaining an apartment, for lowering car insurance rates, for purchasing or leasing a vehicle. Coerced debt traps victims in this abusive relationship, or if they leave, they are financially burdened for years to come. This bill is not a free get-out-of-debt card. Victim survivor must submit proof and documentation to the creditor proving coercion. Most importantly, it allows the creditor and credit reporting agencies the ability to transfer the debt to the perpetrator where it rightfully belongs. In Nevada, there are no remedies for victim survivors of coerced debt to relieve themselves of the debt or to restore their credit. Requiring creditors and reporting agencies to respond to this issue and cease debt collections from victim survivors empowers the impacted individuals by providing an immediate solution, allowing victims to reclaim their finances and to seek safety and healing. Thank you for your time and support.
Good day, Madam Chair and members of the Hardworking Committee. This is Dora Martinez, representing the Nevada Disability Peer Action Coalition. I did owe many people who have called before me and just bring in another common denominator that people with disability and seniors who obtain disability at the end of when they get older are also very prevalent victim of this, and we wholeheartedly hope that you pass it. And thank you so much. Be safe.
Chair, we have no more callers choosing to testify in support at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 250. Is there anyone here in Carson City wishing to testify in opposition? Please remember to state and spell your name for the record.
Chair Marzola, members of the committee, Connor Kane, Connorcain, with Kerr, Nevada. I'm here on behalf of the Nevada Bankers Association, and we are in opposition to Assembly Bill 250. I do want to first acknowledge and thank the Assembly member for bringing this bill. This is an important topic, and also Ms. Evans and Mr. Norman and Mr. Aldis for the work they do every day. It's very much appreciated, I think, by everybody in our community. The Nevada Bankers Association shares the proponents' concerns for victims of fraud, abuse, and theft, including coerced debt. We understand that coerced debt is a real and devastating crime and that an often abusive criminal actor commits against their victim. And we agree there is valuable and important work to be done to help a victim move forward from their crimes of their perpetrator. Unfortunately, we believe Assembly Bill 250 is fundamentally flawed as written, as it does not address the cause of the coerced debt or the economic abuse. It instead shifts focus and liability to a creditor who is not at all involved in the criminal activity. By doing so, credit in Nevada would carry higher risk and consequently be more limited and or more costly for Nevada consumers. However, more importantly for the problem at hand, the abuser would be left completely free to find their next victim. We strongly urge the committee to consider refocusing Assembly Bill 250 to hold the abuser accountable, both criminally and financially, as this will help efforts to stop domestic violence and financial abuse and prevent it from happening in the future. We have a number of concerns. I'm going to try to distill these to stay within my time here, Chair Marzola. But they really fall into two buckets. The first bucket is the scope of the bill. And when you look at the bill and you look at debt, not being defined, I know there are some exemptions in the conceptual amendment, but it's really any unsecured debt You look at the definition of creditor, it's anyone to whom a debt is owed. You look at economic abuse in the bill, and the definition is lengthy and has lots of semicolons and ors and ors and ors. It's unbelievably broad and inclusive. You look at coercion and how it's defined. Again, extremely broad, extremely comprehensive. I think another problem that a few folks have mentioned, this includes debt in good standing, and it includes payments that have already been made, which frankly is technically, I think, not debt once those payments have been made. But those are also challenges. I think for us, though, more concerning than the scope and how broadly this is written, and I forgot to mention, too, we talked about proof, and I have it somewhere in my notes here, adequate documentation. I would look at, encourage folks to read that definition fully, read who some of the third-party individuals are who can essentially sign that affidavit when you get the opportunity. But the process, frankly, is more concerning to us than just the scope. There's a claim that can be made orally. The claim then must be rebutted by the creditor, so we're fundamentally shifting the burden in this bill. And again, the creditor, and in our case, the banks, have absolutely nothing to do with the abuse. We believe there should be, law enforcement involved. There should be a judicial process. We have this for fraud, for ID theft laws. I think we clearly need a better pathway for victims in Nevada when they've suffered economic abuse, coercion.
Mr. Kane, if you could wrap up your comments, please.
Thank you, Chair Marzola. The Nevada Bankers Association is committed to working with the bill sponsor and proponents, but at this time, respectfully request your opposition to Assembly Bill 250. Thank you.
Good afternoon, Chair and members of the committee. My name is Harrison Bond, Harrison, and I'm with Brownstein. I represent the Nevada Collectors Association and the Latin Chamber of Commerce. We appreciate the intentions behind the bill, but we are in opposition to AB 250. We want to thank the sponsor and the stakeholders for listening to our concerns and trying to work with us. We have no intention of seeking to collect debt from victims of domestic violence when that abuse created the debt in the first place. Our concerns are with the definitions and the proposed procedure in AB 250 that we believe creates a system ripe for manipulation. First, and as Mr. Kane mentioned, the definitions for coerced debt and economic abuse are very broad. They could apply to many debtors' claims that do not involve domestic abuse. Second, the bill flips normal process on its head, as the person making the claim does not bear the burden of proving that claim. Once the debtor starts this process, the creditor must then go to court and prove that economic abuse did not happen in order for the collection efforts to resume. The proposed procedure places an unusual and uncomfortable burden on creditors. Along with increased litigation costs, creditors seeking to collect otherwise valid debts for goods or services rendered may simply give up pursuing, even though those claims have good reason to believe they are suspicious. As mentioned by Assembly members Cole and Urick, this could have some unintended consequences on the market as a whole. We had a proposed amendment that would have put the burden of proof on the before the collection efforts stopped. Once proved, the debtor would then receive most, if not all, the protections otherwise afforded by this bill. You have our commitment to continue working with the sponsor throughout this process as there's new amendments being considered, but for now we are opposed. Thank you.
Good afternoon. My name is Brian Reeder, speaking on behalf of the Nevada Credit Union League. The NCUL serves more than 400,000 members statewide. And first, the credit unions in Nevada certainly sympathize with all victims of financial and domestic abuse. And we want to thank the bill sponsor and proponents for taking the time to meet with us and listen to our concerns, and acknowledging the proposed amendment removing secured debt from the bill is actually helpful. But that said, NCUL is opposed to the bill, including with the amendment presented today. Just to summarize our opposition, AB 250 creates a statutory presumption that the victim is not liable for the debt without meeting any burden of proof. And once that burden shifts, the creditor has to prove liability for whoever is ultimately at fault, whether it's the abuser, the victim, or perhaps both, and then face a presumption by the court that the victim is telling the truth, and the creditor, who of course has done nothing wrong, is not telling the truth. There are probably various alternatives and avenues to protect individuals from suffering the effects of financial abuse, and the Nevada's credit unions are welcome broader discussion on the topic. We look forward to speaking more with the bill sponsor. Thank you.
Good afternoon, Chair Marzola, members of the committee. Amy Sjogren, that's Shogren with Black and Wadhams, representing the Vegas Chamber. We are opposed to AB 250, and we'd just simply like to echo the comments of our colleague, Mr. Kane, and those who are also in opposition, and look forward to working with the bill sponsor. Thank you.
Is there anyone else in Carson City wishing to testify in opposition? I see you guys are already seated in Las Vegas. You may begin when you're ready. You each have 2 minutes.
Good afternoon, Chair Marzola and committee members. My name is Eric Cardona, Cardona, representing the Henderson Chamber of Commerce and our members that are over 2,000 members, most of which are small business owners, here in opposition to AB 250. While we appreciate the intent to address economic abuse, the bill lacks crucial safeguards. The overly broad definitions of economic abuse and coerced debt allowed any debt to be challenged with minimal proof, opening the door to widespread.
Seems like we're having technical difficulties. 1 minute recess. So it seems like the entire building is having issues, and so our recess is going to be a little longer than 1 minute. So if you want to get up, stretch your legs, drink water, we'll be here for a little bit. We will now come back to order. I am going to close the hearing on Assembly Bill 250, and we are going to work session. It is customary for the committee to take testimony or otherwise rehear the bill during a work session. However, I may invite a witness to come forward for clarification or questions during our consideration of the measure. We will start with Assembly Bill 163. Mrs. Thomas.
Thank you, Chair. Assembly Bill 163 enters into the Counseling Compact. It was sponsored by Assemblymember Hafen, heard on February 26th, and there are no proposed amendments.
Committee members, any questions? I don't see any. I'll entertain a motion on Assembly Bill 163. I have a motion from Vice Chair Howdigi. Is there a second? Second. I have a second from Assembly Member Monroe Moreno. Is there any discussion on the motion? I don't see any. All those in favor, say aye. Aye. All those opposed, say nay. Motion carries. Our next Assembly Bill is, oh, sorry. All right, I will assign this to Assembly Member O'Neill. I know you love compacts. Okay. Next is Assembly Bill 174.
Thank you, Chair. Assembly Bill 174 revises provisions relating to telecommunication providers. It is sponsored by Assemblymember Marzola, heard on February 21st, and there are no proposed amendments.
Assembly members, any questions? I don't see any. I'll entertain a motion for Assembly Bill 174. So moved. I have a motion from Vice Chair Howdigi. Is there a second? Assemblymember Torres, oh, who was that? Oh, Assemblymember Kasama. Any discussion on the motion? All those in favor say aye. Aye. All those opposed say nay. Motion carries. I'll assign that floor statement to myself. Next is Assembly Bill 230.
Assembly Bill 230 enacts the Audiology and Speech-Language Pathology Interstate Compact, sponsored by Assemblymember Marzola, heard March 7th, and there are no proposed amendments.
Members, are there any questions on Assembly Bill 230? I'll entertain a motion. So moved. I have a motion from Vice Chair Howdigi. Second? Assemblymember Torres Fawcett. Is there any discussion on the motion? I don't see any. All those in favor say aye. Aye. All those opposed say nay. Motion carries. I'll assign that statement to myself. Our final work session is Assembly Bill 258.
Assembly Bill 258 revises provisions relating to brokerage agreements. It's sponsored by Assemblymember Zermano Moore, heard February 24th, and there are no proposed amendments.
Members, are there any questions? I don't see any. I'll entertain a motion on Assembly Bill 258. So moved. I have a motion from Vice Chair Howdigi. I have a second from Assemblymember Monroe Moreno. Is there any discussion on the motion? All those in favor say aye. Aye. All those opposed say nay. Motion carries. I will assign that floor statement to Assemblymember Moore. It's a Monday. No, to the actual Assemblymember Moore. This concludes our work session. And just so everybody knows, even though I closed the hearing on Assembly Bill 250, we are just closing it in hopes that the internet and the phones are back up. If they are not back up today, we will re-agendize on Wednesday and reopen Assembly Bill 250. 1 minute recess. This meeting will come back to order. I will reopen Assembly Bill 250, the measure which revises provisions relating to certain debt. We were in the process of taking opposition testimony in Las Vegas. I see someone at the table. Please remember to state and spell your name for the record. You have 2 minutes. You may begin when you're ready.
Good afternoon, Chair Marzola, members of the committee. My name is Roberta Olinger Johnson, at ROBERTA OHLINGER JOHNSON. I'm speaking today on behalf of the Creditors' Rights Attorneys of Nevada. We represent creditors in all courts in the state of Nevada, and I have personally represented abused individuals both in civil and in family court, and I have even represented creditors in family court, believe it or not. CRAN supports the establishment of an affirmative defense of coerced debt, which does not actually currently exist in the law. We submitted an amendment supporting that position. I have personally been in court where an individual admits that it is her debt, and then the court is unable to validate her defense because Nevada law doesn't recognize coerced debt as a defense. So I think that is actually the piece of the puzzle that is missing here in this bill. We are also concerned about the ability to parse between legitimate and illegitimate claims under this bill, both as drafted and as amended. We think that should be done by a judge, not by us, with guardrails, and that includes the family law judges. To the extent this bill seeks to punish the creditor who is also damaged, we do oppose it. We are also worried about people who have accepted the benefit of the debt, but now seek to disclaim it. And we will continue to work with the sponsor to resolve our opposition. Thank you.
Thank you for your testimony. Is there anyone else in Las Vegas wishing to testify in opposition to Assembly Bill 250? I don't see anyone walking up. Broadcast, is there anyone on the line?
If you would like to provide testimony in opposition to Assembly Bill 250, please press star 9 now to take your place in the queue.
Hi, this is Andrew Levitt, representing the Nevada Mortgage Lenders Association as the chairman of the Board of Governors in opposition for AB 250. The reason for our opposition is essentially it shifts the entire liability of the responsibility over to the creditors. The vagueness is very wide and broad, which can be quite a bit of an overreach. And then also the practical implementation of such bill. But nonetheless, this would be the reason that we would be in opposition for it. Andrew Levitt, ANDREWLEABITT, Chairman of the Board, Chairman of the Governor's Board. Oh my goodness, Chairman of the Board of Governors, Nevada Mortgage Lenders Association. Thank you.
Good afternoon, Honorable Chair and members of the committee. My name is Chris Quigley on behalf of the Consumer Data Industry Association in respectful and compassionate opposition to AB 250. CDIA represents consumer reporting agencies, including nationwide, regional, and specialized credit bureaus, as well as background check companies and other entities in the consumer reporting ecosystem. While we've not seen the proposed amendments discussed today, we have concerns with the bill as presented. First and foremost, the Fair Credit Reporting Act includes clear preemption provisions that prohibit states from regulating areas of consumer reporting covered under federal law. The proposed legislation conflicts with these federal provisions, raising significant compliance concerns. In addition, AB 250 does not establish a rigorous process for determining whether a debt is truly coerced. This could lead to inaccurate credit reporting, which could result in the removal of valid debts from credit reports based on unverified claims. Credit reporting agencies rely on accurate data to provide fair and objective credit assessments, and the inability to maintain precise records could disrupt lenders' ability to assess risk properly. For these reasons, we respectfully oppose AB 250. Thank you for your time and consideration.
Chair, there are no callers to provide additional testimony at this time.
Thank you. We will move to testimony in neutral. Is there anyone here in Carson City wishing to testify in neutral to Assembly Bill 250? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
Thank you, Chair. We do not have any callers to provide neutral testimony at this time.
Thank you. Assembly Member, would you like to give any final remarks?
Thank you. We're happy to be able to close this one out today. Thank you for the opportunity to present this important bill today. The proposed legislation shifts the burden off of our most vulnerable Nevadans and puts victims in a better position to win their cases of coerced debt while still requiring a substantial burden of proof to be put substantial burden of proof for judicial review. We genuinely appreciate the dialogue with stakeholders, and we look forward to continuing that and hope to find a middle ground that meets their concerns, that addresses their concerns, and also meets the objectives of the bill. Committee members, your support for this bill can help free victim survivors from control of their abusers. By shifting unjust debt to perpetrators, you give survivors a real chance to rebuild their lives with hope and independence, and we hope you'll support this important bill. Thanks so much.
And thank you for your presentation today. I will now close the hearing on Assembly Bill 250. I will now open the hearing on Assembly Bill 319. This measure makes revisions relating to providers of health care. Good afternoon. You guys may begin when you're ready.
Thank you, Chair. Good afternoon. I'm Assembly Member David Orientlicker, representing District 20 on the southeast side of Las Vegas. Thank you for the opportunity to present Assembly Bill 319, which I am sponsoring on behalf of the Nevada Board of Medical Examiners. This bill is largely about updating and cleaning up existing statutory language, and Sarah Bradley from the board will walk us through those revisions. Before I turn the presentation over to Ms. Bradley, I'll discuss a couple of provisions that I added. One is to address our problem of physician shortage. We've heard a lot about it. Under existing law, we treat doctors educated and then who have residency training in Canada similarly for licensure to doctors educated and have residency training in the United States. Section 14 does the same recognition as Canada for doctors from the United Kingdom, Australia, and New Zealand. How did I pick those three countries? The American Academy of Family Physicians, for purposes of board certification for family physicians, has reciprocity with those three countries in addition to Canada. So that made me think if the Academy of Family Physicians is comfortable, fuse physicians from those three countries equivalent to Canada, that made sense for us. So that's in Section 14. The other thing I added to what the board came with was to address the problem of undetected heart disease in teens, and that is in Section 7, 68, and 72, and adds a screening requirement so when minors are getting their routine physical examination that doctors, so the reasons why it's Section 7, 68, and 72 is to pick up medical MDs, osteopathic physicians, advanced practice registered nurses, and physician assistants. When any of those professionals are doing a routine exam, that they ought to add in screening for cardiac disease. What we have in those sections, it's in the same in all three, 7, 68, and 72. I'll be working more with pediatric cardiologists. We don't have quite right exactly how the screening should be done, so I'll be reaching out with and talking to the pediatric cardiologists to make sure we have it right. So that's what I have. And now, Ms. Bradley.
Good afternoon, Madam Chair and members of the committee. Sarah Bradley, Deputy Executive Director on behalf of the Nevada State Board of Medical Examiners. The first section of the bill changes so currently the board issues something called a special purpose license, but it's really a telemedicine license. It's for folks that are licensed in Nevada and doing only telemedicine services. And instead of calling it special purpose, we think it's more clear to just change that to telemedicine. So there's some changes throughout the bill with that. Section 3 adds a definition of charging document. We also are trying to be consistent with NRS Chapter 622A. That was not something the board always followed, but I want to say in approximately 2015 that was changed, and so we're just trying to update our laws there. And so we're going to be using the term charging document for a formal complaint that starts a disciplinary process, and that's the 622A language. Section 4 and 5 are the two that Assemblymember Orntlicher just discussed, adding Canada, United Kingdom, Australia, New Zealand to be essentially equivalent foreign medical schools. It does also allow the board by regulation to add other jurisdictions if and when it deems appropriate by regulation. Section 6, this adds a definition for progressive with regard to postgraduate education. So existing law says that a person must complete progressive postgraduate education, but there's not actually a definition of that. And so we wanted to clarify that so that we have some specificity with regard to that. We do have an amendment that we have presented that will change this slightly, and I hope you all have copies of the amendment. If not, I have a couple copies. Instead of saying a break of one school year, we are suggesting, actually, I think 12 weeks. The amendment says 4, but I think 12 is what the board is going to actually ask be submitted, and I need to update that. And then also making it clear in paragraph 2B there in section 6 that they enrolled and completed a program that's closely related. Again, just to clarify that. Section 7 is the pediatric cardiac screening. Section 8 just updates with some of the changes that this bill has with regard to definitions. Section 9, number 7, this adds, and this is the practice of respiratory care. So currently, our practitioners that are licensed to do respiratory care in Nevada actually are holding 2 licenses. They have one from our board, and they have one from the Division of Public and Behavioral Health, and we're trying to just require them to have one. And so the change there adds performance of laboratory testing authorized by NRS 652.210. And again, the intent there is just to require 1 license instead of 2. It's my understanding we're one of the only states that actually does require 2 licenses for respiratory care practitioners. Section 10 is adding students of perfusion to individuals who can perform duties under the supervision of a licensed perfusionist. And it was just because currently students of perfusion aren't included, and we want to make sure they're included because other license types are able to perform services under supervision while they're enrolled in a program. Section 11 moves the conducting of examinations for licensure and system of scoring actually to regulations potentially, but we utilize a national exam, and so we don't have our own criteria for that. We use the national exam, but just kind of updating that language there. Section 12, this adds a provision about communication between the Nevada State Board of Medical Examiners and the Board of Osteopathic Medicine, and this is with regard to simultaneous licensure. So right now, individuals who are licensed as physician assistants and anesthesiologist assistants sometimes are licensed by both boards, and so this is just to ensure that we share information regarding who is licensed with each of us, because there's actually a reduced fee that's available to them when they have the 2 licenses with the 2 boards. And the reason they do that is if and when they're supervised by either a medical doctor or a doctor of osteopathic medicine. They have to be licensed by the board that licenses the physician that's supervising them. Section 13 makes a very similar change. Section 14 updates NRS Chapter 630-160 to try to make it more clear, because this provision actually does a lot of things. And so Basically, we're clarifying that everyone has to pass the examinations, the national examinations, even people that are American Board of Medical Specialties. They still pass them. They just, in the amendment we are hoping to add something that says that they can actually have more attempts, because in regulation we have a number of attempts of the exam. But if someone is certified by the American Board of Medical Specialties, as long as they've passed the exam, even if it took longer, we still license them because of their certification. And so we're moving that, updating the language regarding equivalent foreign country to go along with the changes from Assemblymember Ortlicker throughout here. And then updating the fine amount. Currently, it says the fine amount is $5,000 for providing false information to the board in conjunction with an application. Last session, the legislature approved increasing the fine in disciplinary actions from $5,000 to $10,000, and I think this is a change I believe was drafted by Legislative Counsel Bureau, just updating that $5,000 to $10,000 there to be consistent with the rest of the chapter. Section 15 is updating our endorsement provisions, again, to make it more clear and more clean so that we can use these more easily. So we're changing from in effect to active and in good standing. Again, they have to pass the examinations, an examination that's approved by the board in order to have a license. Even if it's endorsement. And then again, updating here the requirements in B3, 1, and 2 there, Roman numeral 1 and 2, with regard to requirements that the board may have by regulation with regard to endorsement applications. Section 16 is clarifying. Now, NRS 630.1607 is used for veterans, surviving spouses, etc. It said that in the fee chapter, but it didn't say that in the exact, in 1607. So we wanted to put it here because this is where people look. So we wanted to clarify that this is for those members or those folks, and they do get a reduced fee under NRS 630.268. We also are removing the American Osteopathic Association reference in section 16 because that doesn't, our board doesn't use that. That would be something for the Board of Osteopathic Medicine. So that's why that's being removed. Let's see. And then section 17 is removing a reference to 630.1606. That's another endorsement provision, but if we have the 1605 provision updated, that's the only one we will need. And so we're removing 1606. Section 18, again, removes a reference to 630.1606. Section 19 adds the equivalent foreign language equivalent foreign country language to the bill, again, updating it, not just Canada. Section 20, again, removes a reference to NRS 630.1606. Section 21 updates the requirement for licensees to have an electronic mailing address on file with the board. I think all of them do, but we just wanted to update that in here. We do send a lot of notices by email, like renewal notices, things like that, and so just making sure that they do keep their email address up to date. Section 22, this updates the language regarding inactive practice. So if someone hasn't practiced for more than 24 months, currently only physicians were addressed here, and we wanted to update that to include all of our license types and also to make it clear what the board may do to evaluate competency if someone hasn't practiced. So this is generally for new applicants who have not practiced in their field for more than 24 months, or it could be someone who's been inactive for 24 months or more and now wants to activate but hasn't practiced. If they were practicing in another state, it wouldn't apply. It's just if they truly were inactive for 24 months and not practicing. And generally speaking, what the board wants to do is have them take an examination or sometimes a preceptorship. Those are usually the things we want to look at. And so this is just ensuring that everybody is eligible for that same kind of review in that situation. Section 23 removes a reference to 630.1606 because it's going to be repealed. It also updates for volunteer licensure that the board isn't required. Instead of it's a must give the license, it's a may. We just thought that there's some discretion. We don't get very many of these at all, but just for, I guess, public protection, we don't want to have to give them every single time if there was one that for some reason there was a problem. Section 24, this talks about administrative physicians and just updating the requirements here so that the requirements are specified by regulation of the board. I believe there already is a regulation on this, but I think the changes to 630, 160 make it just be regulation at this point. Administrative physicians don't provide clinical care, but they do sometimes lead different entities with regard to medical knowledge, but they're licensed in kind of a more limited capacity where they don't provide patient care. Section 25, this is repealing a special license because we actually don't need this. NRS Chapter 630.047 already allows people that are licensed in another state to come to Nevada to consult with the Nevada physician. So we don't do this special license because there's a different statute that allows it. And the way it's done is they have to tell the board in writing, and then the Nevada licensed physician keeps the medical records for that patient for the time prescribed by law. So they're kind of responsible for the treatment and the records for that patient. This also updates the references to special purpose license to telemedicine license. Section 26 is, again, incorporating that equivalent foreign country language to the bill so that that's in all of the appropriate statutes. Section 27, similarly, is adding the equivalent foreign country language, excuse me. Section 28 is just updating requirements for denying a license. And it's just adding a reference to 630.257, as well as equivalent foreign country. Also removing the language about legally entitled to work and remain in the United States. I'm not sure how that stayed, because I know several years ago the legislature removed that for all licenses, but apparently that language remained in for residents, and so that's just being removed. Section 29, this has to do with the simultaneous licensure provision. So this is simultaneous licensure for physician assistants. Current law allows them to be licensed and pay a reduced application and a reduced registration fee. This adds in, if they don't get licensed within 1 year with the Board of Osteopathic Medicine, that they actually owe the board the difference in the reduced fee, if that makes sense. Because we do know there are some that have said they're going to, and then they didn't, and they also didn't pay the full fee. So Section 30 updates NRS Chapter 630.268. This is our fee provision. So we are updating here a couple, the duplicate identification card, just a couple outdated things we don't need. And then clarifying again that NRS 630.1607 is for, well, we've already updated it in that provision that it's for veterans and surviving spouses and spouses. And so just removing it here because it would be in the chapter twice. Also removing a provision reference to 630.1606 because that is going to be repealed in this bill. Section 31, again, deals with the simultaneous licensure, and this is for anesthesiologist assistants. And just saying basically the same thing as we did for physician assistants, that if they pay that reduced fee and they don't get licensed with the other board within 1 year, they would owe the board the difference in the reduction that they paid. Same in Section 32 for anesthesiologist assistants. I'm not sure why we have it so many times for them, but there's I think 3 changes here that are all basically the same thing, that they have to pay the difference in the fees. So Section 32 and Section 33 are the same. Section 34, this is updating just that we're going to, removing Section 3 there. I think it's because, this is perfusionist. Excuse me, I got confused for a second. So right now, we require that they're nationally certified. So a perfusionist is certified by a national group. And so we don't have a separate exam, and this reads like we do. And so we're just removing that, saying that they have to pay the fee and do the things. but they don't have to take an exam that we've set out. And then Section 35 also updates the requirements. So again, instead of saying they pass an exam that we've created, it says that they hold a current valid certification issued by the American Board of Cardiovascular Perfusion or its successor organization, because that's what we do with our other like practitioners of respiratory care, anesthesiologist assistants. They have to be licensed by their national, or certified, by their national group that issues certification and exams. Section 36, this is also just updating renewal requirements, looks like, and also making sure that they comply with that 630-257, which we updated previously. And then temporary licenses, Section 37. This is an important one to recruit new perfusionists to the state. So right now, it says actually they can get a temporary license and it's good for 1 year, but if they fail the exam, it's immediately surrendered. And so we wanted to update that and give them 2 years. So they would get 1 year and then an additional year perhaps to pass the exam. Anyone with a temporary license is being supervised by a fully licensed perfusionist. So for public protection, we think that there's safety there. But this also allows them additional temps. And our other license types do get more time. And we don't do this with any other license type, that if they fail the exam, if they have the temporary license, that they immediately surrender it. So just wanting to update that for them so we can hopefully recruit more folks to provide that care. Section 38, this is also about simultaneous licensure, the new changes for physician assistants, and again, that they have to pay the difference in the fees. Section 39, this is removing, so currently the board is prohibited from requiring a physician assistant to maintain certification. They must be certified when they apply. They don't have to keep it when they renew. This is just removing that prohibition. The board has never required that physician assistants have the certification. I think this was added a few years ago. And so it's just taking out something that we didn't think was necessary. We'd have to actually take action, as in regulation or statute, to require a certification. So removing it doesn't actually, but it does give the board perhaps the option to require it in the future if and when they deem it appropriate. Section 40, this updates, so this is again endorsement by physician assistants, and it just updates that they can't be disciplined or currently investigated if they're going to apply by endorsement. Also removing language regarding civil or criminal liability for malpractice. Not that we don't have this limitation for physicians, so we're trying to be consistent. The way it works for physicians and what I anticipate with physician assistants is if and when they had malpractice history, that would be reviewed by the board on a case-by-case, looking at what it was, how much, how long ago, the type of thing that occurred. So just, again, trying to treat physician assistants not more rigorous than we do physicians here. Section 41 is, again, that same language for endorsement for physician assistants. I don't know why we have two very similar provisions there, but also just making that same language to make sure that that civil and criminal liability language is removed and that they don't have an open investigation. I believe, this is the military one. I apologize. I should know that. So this is the one for spouses, surviving spouses, veterans that are physician assistants, and just clarifying that the same requirements are there for them. Section 42, this again has to do with the simultaneous licensure fees for physician assistants, and then the fact that they have to pay the board the difference if they don't get licensed within 1 year. Section 43, this is something that we've been able to do because I think the others were in regulation, but we want to remove the requirement for a high school diploma or GED. What we need to verify for our practitioners of respiratory care is that they've done the appropriate respiratory care schooling. And we know that colleges in this country, as far as I'm aware, I don't believe any would let you be admitted without having a high school diploma or GED. And so it's not something the board needs to verify, and we're hoping it will help streamline licensure by removing that. We've already removed it for the other license types. Section 44, this clarifies that, so currently there in number 3 in Section 44, we talk about the fact that the board has authority to discipline someone that's licensed by the board if another state has disciplined them, or the federal government or a foreign country, et cetera. We're adding here another agency of this state because we've had a couple situations where other agencies have actually disciplined them, and we don't have, except for the pharmacy board, we don't have a specific authority at the moment to discipline for that. And so we just wanted to make sure that that was there and clear. And then we also wanted to update number 5 there, the engaging by a practitioner in any sexual activity with a patient who is currently being treated by the practitioner. We get questions on this a lot about what does currently being treated mean. And so we're adding that there to say a practitioner shall be deemed to be currently treating a patient if the practitioner has treated the patient within the immediately preceding 3 years and has not discharged the patient in writing. So just this way we have clarity. Section 45, we are updating. Right now it says action taken or obtained against. Really what we want to know is arrests and criminal convictions. And so we're just trying to clarify that because we get questions on this sometimes. And so licensees should let us know if they've had this occur. Also, we're adding there that failure to respond to the board or an investigative committee of the board during an investigation is actually grounds for disciplinary action. And we do have this happen where people won't respond to us, which is hard, obviously, to do an investigation if they're not responding to us. Section 46, this is adding anesthesiologist assistant in here. Just this provision is regarding insurance payouts for malpractice and things like that. Last session, anesthesiologist assistants were added as one of the types of practitioners the board licenses, but they weren't added here. And so we just want to make sure that they are added. And then also we wanted to clarify that insurance company reports for malpractice are public. So currently what the law says, and I don't know why it was a distinguishing factor, but currently both the practitioner and the insurance company have to report to the board. But the law says only the practitioner's report is public, and we want to make the insurance one public as well. We think that's important for public protection. We actually add on our website, if you look up a licensee, it will say malpractice payouts, and it will tell you like how much, what date, a small summary that we know at least what we're told of what occurred. And so we just wanted to clarify that the insurance company reports are also public. 3068, this is the one where the licensee has to report to us. And again, just adding anesthesiologist assistance there for to make sure that everybody is included. And then Section 48 talks about the fact that if we get a report regarding a payment of an award in a malpractice action, that the board will investigate that to determine whether there's something that we need to be aware of with regard to patient care. And we do that. I mean, we already do that. We're just adding anesthesiologist assistants here. We have 5 so far in the state, so we're not having issues with them, but I just want to be prepared if and when it occurs. Section 49, this is just updating, again, existing language, and this has to do with people that have to report. So basically any person can file a complaint, and then some people need to file a complaint, like a licensee, medical school, et cetera. We just wanted to add or assisting in the practice of medicine. That includes anesthesiologist assistants there specifically. Also, this is clarifying in number 7 that if the board receives a report from the Attorney General's office, that's 228420, it has to do with Medicare fraud. Or an insurance fraud, I believe, as well. We proceed as if there's been a complaint filed. So we treat those as a complaint. And that means that triggers an investigation. Section 50 updates the disciplinary action language. So instead of saying, sometimes we get confused because, again, there's consumer complaint, which is what I call the little c complaint, and then the big C is the formal complaint that starts disciplinary action. So we're just clarifying here that a written charging document, which we talked about earlier, that's the 622A language, that's the formal complaint, just updating that language so it's more clear. So we have a consumer complaint, little c, and then a charging document, that would be the formal complaint that starts disciplinary action for a licensee. And so updating this information. And those complaints currently are filed by investigative committees. So it's 3 board members on an investigative committee, review all complaints, and decide when it's warranted to file a complaint against the licensee. Section 51, just updating the language that the investigative committee reviews each complaint that's within the jurisdiction of the board. Sometimes, as you can imagine, we get complaints regarding people that aren't licensed by us or related to issues that we don't have jurisdiction over, like maybe some private issue with them, I don't know, their landlord-tenant dispute or something like that. And so we don't need to burden the investigative committee with things that we can't actually act on. And so staff, we want to make it clear that we can screen those out, and so that the investigative committee is truly looking at patient care and other violations of Nevada law, Chapter 630. Also updating the language here, formal complaint to formal charging document. Section 52, and this has to do with an examination for competency or if there's a concern. So right now, basically, if the board or an investigative committee has a reason to believe that someone maybe isn't practicing with reasonable skill and safety to patients, they can order an evaluation of that person to test their competency and to make sure that they're practicing safely. And so this is adding anesthesiologist assistant to this statute. We actually, I believe this was included in our regulations for anesthesiologist assistant, but it makes sense to include them in the NRS where everyone else is. And so that's what 52 is doing. And then it's also saying, kind of clarifying the language, because it talks about except in extraordinary circumstances, if a person doesn't get the evaluation when the board orders them to, it says that right now it's an admission of charges. That might be helpful, but at least other boards have this grounds for immediate suspension, because it makes sense that if we're concerned about your ability to be safe and you don't want to be evaluated, perhaps we should be concerned about your ability to be safe. And so that should be grounds for an immediate suspension of the license. Section 53 is removing just a reference to NRS 630.324 because that's being repealed. Section 54. This is updating and kind of clarifying summary suspension procedures that the board uses. So the board can, pursuant to NRS 233B 127 sub 3, that's where all regulatory bodies get their authority for suspending a license. We're clarifying here that the board could suspend the full license, but they could also suspend ability to to prescribe some smaller thing, and of course a summary suspension is done before a hearing happens, but it's only done obviously in really emergency situations to protect the public. So just clarifying that the summary suspension could be restricting the practice. It could also be the entire license, and then Section 2 there, or number 2, is being struck because actually 233B 127 sub 3 says the hearing has to be within 45 days. And our law says 60. And so that's a conflict. So it's just making sure we don't have that conflict anymore. And then also clarifying again that if there's a summary suspension of a license or restricting of the practice, that the court can't stay that. That's the only exception. They can stay other orders that we do, but if it's a summary suspension because we believe health, safety, welfare is an immediate danger, those orders the court can't suspend. And so just adding that restricting the practice there. Section 55, is adding all the license types. Currently, it just said, and also the summarily restricting. So just making sure that those two provisions are clear and squared away with that. Section 56 says the formal charging document. So again, updating that language. Also, with number 6, clarifying the language of what we provide to other entities. Since we're not going to we don't do oral exams. That's something I think the board did some time ago, removing that. But if the board does do an examination, it could include a copy of that. and then also communicating and cooperating with or providing documents to, and this should help speed up credentialing. So obviously there's licensure with the board, but once someone's licensed, they then have to get credentialed with an insurance company or a hospital or other entity. So here the board would be able to provide, if the licensee authorizes it, we could provide the direct source verification documents we received, and that should speed up their credentialing process and get them to work quicker. Section 57, again, updating complaint to charging document throughout. And also, this is earlier we talked about that report that we get from the Attorney General's office pursuant to 228-420, just removing it here because it was mentioned earlier. And then also removing number 6 there because we're following 622A, and 622A already addresses the process for a hearing and the order of a hearing, so we don't need this number 6 there. Section 58 is updating the service provision. So currently, actually, existing law requires that we publish in a newspaper if we can't serve a licensee. And generally, I mean, many of the licensing boards, I used to, before I worked with the board, worked with a bunch of licensing boards at the Attorney General's office. Most of them have transitioned to this sort of service that if you send it to the last known address by personal service or trackable mail, like certified mail or FedEx or something like that, and it's returned, that's still considered actual service because they have a duty to update their address with us within 30 days. And so they should be keeping their address current. And so instead of publishing in the paper, this is updating that process. Section 59, again, updates the language regarding a complaint or the filing of a charging document. Removing references to the complainant with regard to the adjudication. Generally speaking, the board is supposed to make their decision based on the evidence presented. The person can make a comment at the end, but normally they're not allowed to provide comment before the matter is adjudicated. And so we're clarifying that here. Section 60, this is updating basically contempt language in a hearing and making sure it's clear that really this is referring to respondents or witnesses, not just any person. There was actually a situation where someone tried to say that the attorneys representing the board were, in violation of this, and that's not what this is intended to be. Is it's for respondents or witnesses. Attorneys have to follow their own code of conduct, and that's enforced by the state bar. And then also 622A does say that if someone is being, they can be asked to leave the hearing, and that does include attorneys. So Section 61, this is removing this provision there that's being struck, the court shall not stay. That was actually held to be unconstitutional by the Nevada Supreme Court some time ago. And so this hasn't been happened, but we're just updating it because it should have been taken out. So what this means is if someone's disciplined, they get to appeal to the district court, and the court can stay that pending the outcome of the petition for judicial review. Section 62, this is updating basically who can come to the board if and when they have their license either limited or summarily suspended. They can come to the board and how that can happen, and also making sure that it's not a revocation, because that's dealt with in a different provision, and revocations don't just come back. That means your license is gone and you have to apply again as a new applicant. But if your license is suspended or limited, you can petition the board to remove that suspension or that limitation on your license. Also, again, just including all of our license types here because they weren't all included initially. Section 63 is updating essentially the good faith provision. So right now we say that if one of our it actually says just physicians currently, if they provide information to the board or another government entity in good faith, they're protected from liability for that. And we want to make sure all of our licensees are included in that, because all of our licensees potentially could need to either give us information or another government entity or somehow cooperate with an investigation. And so this should cover all of our licensees as long as they're acting in good faith. And so that's why that's being updated. Section 64 is being updated to include equivalent foreign countries, again, in the language of for this laser surgery and this intense pulse light therapy, who can provide those services. Section 65, the intent of Section 65 is basically, so right now, most doctors' offices are permitted by the Division of Public and Behavioral Health to provide anesthesia services in their offices or the facilities where they're working. If it's like a different kind, like a surgery center or something like that, they're all permitted. But there's kind of a loophole in that if you're doing tumescent anesthesia, they're not required to be permitted. And sometimes we see unscrupulous folks doing tumescent anesthesia where they shouldn't be. So the intent of this and what it's supposed to be doing here is saying that if you're doing tumescent anesthesia in a place that's permitted, granted, it doesn't have to be if that's all they're doing, but if it is, and I think a lot of the reputable places, they're already permitted because they're doing other kinds of anesthesia as well, they can do that. If they want to do tumescent anesthesia in a place that's not permitted, the board will make a regulation on if and when, maybe a permit. We're not really sure yet how we're going to draft that, but our goal is to try to make sure we don't have this happening because it's very dangerous for patients. We've had patients nearly die, actually, in some of these situations. And so we just want to make sure that we can keep people safer. And so again, and tumescent anesthesia is kind of a special thing. It's local anesthetic and epinephrine. And it's usually used most frequently, I think, in liposuction, actually. And again, liposuction is a very dangerous procedure in general because of the loss, the volume loss and things like that. So we want to make sure that that's not being done just anywhere. And then the next part of the bill actually adds to Chapter 632, which is the Board of Nursing. So this is adding the definition of medical assistant. Right now, there's a lot of confusion because medical assistant is in our chapter, and this adds it to their chapter too, so that nurses can provide direction to medical assistants to perform duties. And then also this adds the cardiac screening language in Section 68 there for advanced practice registered nurses that may be doing that screening. And I think 69 just incorporates the definition of medical assistant. It does give the nursing board in Section 70 the duty to make regulations regarding the supervision of medical assistants by nurses. And Section 71 adds potential disciplinary action for nurses who fail to adequately supervise a medical assistant pursuant to the regulations of that board. Section 72, this adds the cardiac screening language for the Board of Osteopathic Medicine, just so that we're incorporating that language to everyone that might be doing those kinds of screenings. Section 73, also, this has to do with the simultaneous licensure. So 73, 74, 75, that is that board and our board will share information regarding the simultaneous licensure to make sure that the provisions are enforced. Section 76 updates. This has to do with the simultaneous licensure fees and says that same thing as for us. If they tell them they're going to be simultaneously licensed and then they aren't, that they would have to pay the difference to that board for that. 77 does the same thing for anesthesiologist assistants. 78 also for anesthesiologist assistants has to do with the simultaneous fees. And 79 also for physician assistants doing the simultaneous licensure fees, and 80 as well, and 81 as well. Just making sure that that language is added throughout. Section 82, this amends 652-210. We talked about that at the very beginning. That has to do with the scope of practice for the practitioners of respiratory care. So we added that addition that they can do the testing there. This clarifies that a practitioner of respiratory care licensed pursuant to Chapter 630, which is our board, can perform laboratory tests classified as a waived test without obtaining that second license, that certification, if they've been properly trained and it's within their scope of practice. So it has to be something that they know how to do, that they should be doing, not just any test at all. That's why that language is there, because there are a lot of tests that are the waived tests. And then 83 adds some language regarding the expiration of the special purpose license, and obviously the fact that now it's going to be telemedicine license. And what's being repealed is, as we talked about, 630-1606, 630-2692, 630-2693, and then 630-324. And that is, I believe, everything in this bill.
Thank you for a very thorough presentation. Committee members, are there any questions? I don't see. Oh, Vice Chair Howdigi.
Just a very random question, but I do have one. On Section 15, and I know this language is repeated like in a couple other sections, but I just want to ask, is active and good standing the same thing as is in effect?
Sarah Bradley, Deputy Executive Director on behalf of the board.
I'm sorry, it's Section 15A.
Yes.
Where it says at the time of the applicant files the application with the board, the license is, in the new language is active and in good standing. Is that the same thing as is in effect? Because if it's in effect, that means they automatically, like, they are in effect. And with a doctor shortage, I don't want to like prolong any license.
So it should be the same. I mean, that is our intent, that it's the same. In effect is not language, though, that is often used. And so we get questions about it because in effect, usually we refer to licenses being active, inactive, good standing, not in good standing. And so I guess,
so yeah.
I mean, our intent is that it be the same.
Committee members, any additional questions? I don't see any. I have a question. Maybe a couple. On page 7, section 3. So I know part of this bill is requesting that now not only Canada is included, but the United Kingdom, Australia, and New Zealand, correct?
David Ornlicker, that's correct. And as Ms. Bradley said, and to give them authority, if there are other countries that seem equivalent, they could act. We wouldn't have to come back to us to add Switzerland or France.
Thank you for that, because that was going to be my follow-up, because for Section 4, subsection 2 states, then any other country designated by regulation. How do you make that determination if a country is appropriate? Because obviously coming to the legislature puts some safeguards, right? You can't just blank accept every country, especially if our courses and our rules are very different. So that's my question. So we're taking that safeguard out, so the legislature essentially will no longer have that authority, and it's given to the board. But how are you guys going to make that determination? Do you have a process in place?
Madam Chair, Sarah Bradley, for the record. We don't have a process in place because we don't currently have this. What I would say is when we make a regulation, we have to have multiple public meetings. We have a public workshop, we have a public hearing. We also discuss it at a board meeting for adoption. So at least 3, usually 4 though, because we have the initial draft reviewed by the board. So there's 4 meetings where it's discussed publicly, and it would come to the Legislative Commission. And so the legislature would have a role in approving or not. So we wouldn't be doing it just on our own. I only foresee us using this if there's something that comes to our attention that we need to include. I our staff doesn't speak multiple languages, and so it would be hard to verify with these other countries sometimes. And so I don't think it's something we're intending to do unless there's something that really comes to our attention as being necessary for us to deem equivalent. And then we would go through the regulation process, which, again, multiple public meetings and approval by the legislature prior to that regulation coming into effect. Hopefully, we would garner enough public comment and input that we would be doing the right thing and keeping people safe by making this addition.
Thank you for that response. In a quick follow-up, just from my understanding, so are we talking about doctors that have been practicing in their country, or are we talking about medical students that just graduated and now are seeking to come here and essentially maybe do their residency?
Madam Chair, Sarah Bradley for the record. My understanding is there are many doctors that are currently practicing in Nevada that have done their medical school in another country. They come to the United States and do their residency, and then they're eligible for licensure under the traditional path. This would allow them, if they're licensed in these other countries, as well as if they've gone to school there, either way. But we currently do allow students from other countries, as long as the school has to be vetted, and we have a list of schools that are appropriate. But we also, though, they have to do the residency here, and that's in an approved program as well. And so there's some check on that's not just any school. And so those folks are already coming. This would allow people that are licensed in these countries specifically, as well as that have done schooling in these countries, to essentially be considered equivalent to a U.S. grad.
Perfect. Thank you so much for answering my questions. Committee members, last chance. I don't see any. So if you guys can move back, please, so that I can start support testimony for Assembly Bill 319. Is there anyone here in Carson City wishing to testify in support?
Hi, my name is Jane Grossman. I'd like to do two testimonies. A friend was going to call in, and she had to go to a meeting. So may I have permission? And it's very relevant because she has a kid who has this condition. So her name is Stacy Miller, Staci Miller. And she writes, thank you for allowing me to share my son Seth Miller's story today in hopes of encouraging you to pass AB 319, especially Section 7, 68, and 72, that call for more thorough cardiac screening for children and young people under age 19. My son, Seth Miller, had always passed his wellness checks and annual doctor visits with flying colors, so when he said he wanted to join the track team in his freshman year of high school, we were very supportive. He did a physical in December of 2019, which he passed with no problem, and began a very rigorous training program for the track team to prepare for the upcoming season. In the beginning of March of 2020, he got an infected, ingrown toenail, and we couldn't go to his primary, so we went to urgent care. PA Ashley Owens listened to his heart and was alarmed at a very distinct heart murmur. She said he needed to get into his primary ASAP and to not do any running or exercise until he was checked out. We were in total shock since he had just passed a physical a few months prior, and we never had a doctor tell us he had had a heart murmur or express any concern. The news led us to his primary, which led us to a pediatric cardiologist for an EKG and echocardiogram. He was diagnosed with HCM and immediately put on beta blockers to slow his heart rate, and was told he could no longer do any physical activity that raised his heart rate or he could go into cardiac arrest. We were told HCM is one of the conditions that high school athletes have died from. I truly believe that PA Owens' training and knowledge that alerted her something was seriously wrong when she heard the heart murmur saved Seth's life. That's why SB 319 is so important. I'm fortunate to have a happy outcome and to be able to say Seth is doing well and is now in college studying computer science. Other mothers have not been as fortunate. I strongly urge you to pass AB 319 and improve not only cardiac but all screenings. So that's from Stacy, and I'd like to now share mine. My name is Jane Grossman, and I want to thank all of you for staying past 5 for this. I'm also here in support of 319, especially the sections for cardiac screening. My maternal grandmother died just 3 weeks after I was born. She was a healthy 61-year-old woman when she passed. She went to a party, came home, went to bed, and never woke up. It wasn't until 62 years later from her passing that I can now surmise she probably died from a sudden cardiac arrest due to a genetic heart condition known as hypertrophic cardiomyopathy, also known as HCM. It's a genetic condition that causes your heart to get too big and stiff. It took me 62 years to figure this out because it took that long to learn that I also have HCM. Like so many others, my HCM was there in plain sight, but I wasn't properly diagnosed with the condition until the spring of 2023. Most people with HCM are misdiagnosed or underdiagnosed 2 to 4 times before getting proper diagnosis. In college, after overheating playing racquetball, I was misdiagnosed with exercise-induced asthma. I have known I've had an unusual heart rhythm since my early 20s, and I was told many times over 4 decades, "You're healthy, you just have a weird heart." Well, in 23, I knew something was up. I went to the ER, and the ER doc came in with eyes large as saucers and said, "Oh no, we're going to have to send you downtown." I said, "Why?" She says, "Your heart is weird." I'm like, "I know I have a weird heart." So after many tests, it was confirmed that I have HCM. Had there been better childhood screenings when I was a child, as is proposed in SB 319, I would have known my condition much earlier. We need this bill to ensure Nevada's kids have the best chance of living long and happy lives. As many as 1 in 250 people have HCM, and we want to identify them early. There's no cure for HCM, but there's medicines and procedures to treat the condition. Catching it early can save lives and saves money. Thank you so much.
Thank you for your testimony and staying with us late. Is there anyone else wishing to testify in support? I don't see any. Is there anyone in Las Vegas wishing to testify in support of Assembly Bill 319? Broadcast, is there anyone on the line?
Thank you, Chair. The public line is open and working. We have no callers for support at this time.
We'll move to testimony in opposition to Assembly Bill 319. Is there anyone here in Carson City wishing to testify in opposition? I don't see anyone. Is there anyone in Las Vegas? Please remember to state and spell your name for the record. You have 2 minutes.
Thank you, Madam Chair. My name is Renee Ruiz, Renee, and my last name is spelled Ruiz. I represent National Nurses United, National Nurses Organizing Committee of Nevada, and today we are opposing AB 319, but only in the sections pertaining to RN oversight of medical assistants. And we are concerned that without a delegation process laid out in the bill, and yet the ability to discipline an RN for inadequate oversight in delegation, we see that is an issue. We are more than happy to work with the bill sponsor and stakeholders on how to remedy that and possibly a friendly amendment. Thank you.
Thank you for your testimony. I don't see anyone else in Las Vegas. Broadcast, is there anyone on the line wishing to testify in opposition?
The public line is open and working. We have no callers in opposition for Assembly Bill 319.
Thank you. We'll move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral? No one's walking up. I don't see anybody in Las Vegas. Broadcast, is there anyone on the line?
The public line is open and working. We have no callers for neutral at this time.
Thank you. Would you like to give any closing remarks? Thank you. I will now close the hearing on Assembly Bill 319. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Public comment is limited to 2 minutes. Please remember to state and spell your name for the record. Is there anyone here in Carson City wishing to give public comment? I don't see anyone walking up. Is there anyone in Las Vegas wishing to give public comment? Broadcast, is there anyone on the line?
The public line is open and working. We have no callers for public comment at this time.
Thank you so much. Thank you, committee members, for sticking it out today. Much appreciated. This meeting's adjourned.